Morning.
May I please, my lord, I beg to mention for listing of a writ petition regarding the matter promotion, my lord. In order, what?
Yes. Listing for what? For motion?
Orders, my lord.
For orders?
Yes, my lord.
All right.
Most of it.
Any mention for listing, you give it to the court master. Yes.
Your Lordship, I beg to mention item number 5 of the daily list, Your Lordship. Court number 7.
Yes, what do you want?
Your Lordship, I'm appearing for Shabir Singh, who is a standing counsel for FCI. He is out of station today.
Have you taken consent from the
Taken
petitioner?
consent of the petitioner, Your Lordship.
Because it's a motion matter.
It's a motion matter. Your
Have you taken consent?
Yes, Your Lordship.
Your name?
D. Akram.
Mr. D. Akram, Learned Counsel for Respondent FCI, for Respondent SC FCI, with consent from the petitioner seeks.
Your Lordship, the matter may be fixed on Wednesday if convenient.
Seeks accommodation in the matter. Stop. List this matter on Wednesday. Next.
Lordship, for item 18, I may be allowed to withdraw this matter with liberty, Lordship.
You are for the petitioner
Yes, Lordship.
in item 18. Your name?
B. Das.
MS B. Das.
B. Das.
Learned Counsel for the petitioner submits that she has received instructions from the petitioners not to press the instant writ petition and accordingly seeks withdrawal of the same. Stop. In view of the aforesaid endorsement, the writ petition stands dismissed on withdrawal.
With liberty, Lordship.
You should do not make these piecemeal submissions. If you are seeking liberty, you should have said it in the first instance. Six, withdrawal with liberty allowed. Yes. Ms. Das, your name doesn't appear in the cause list.
Lordship, I'm on behalf of I. Rafiq.
On behalf of Mr. I. Rafiq. All right, next.
May I please, Your Lord, I beg to mention for listing of a my lord, petition on admission column, my lord, regarding his pension, my lord. My lord.
Next.
Next slide. Oblige.
Call the list. Which order?
Lordship, it starts from page number 9, Lordship, operative portion, last page 12, page number 17, Lordship, para 12. I am the first wife, Lordship, and the direction was to pay the family pension only to the first wife, to the petitioner.
So what has happened?
Lordship, as per the full bench judgment, Lordship, the direction was to pay me the family pension. Immediately I have taken the certified copy, Lordship, on...
Where is your representation?
Presentation she has misplaced, Lordship.
Then?
Statement, Lordship, that I have misplaced.
Then you could, before approaching this court, you could have given another representation.
But 1 year has already been elapsed, Lordship, that's why.
Where is your statement?
In Lordship, page number 5, para 6, Lordship.
Para 5.
Para 6, Lordship. She has taken a certified copy
Heard
on...
MSS Kanung, Learned Counsel for the petitioner. This is an application. Under Section 12 of the Code of Contempt of Court Act 1971, read with Article 215 of the Constitution of India for initiating a contempt proceeding against the respondents / contemners for willful disobedience of the order dated 15/3/2023 passed by this Honorable Court, WPC number 3473 of 2022. Stop. The case of the petitioner is that is that that this court, by order dated 15/3/2023 in WPC 3473 of 2022, was pleased to direct the respondent authorities to pay the family pensions to the petitioner in terms of the
Lordship, para number 8, page number 14, it is reflected that there is a full bench judgment, Lordship.
in terms of the full bench judgment of this court. Stop. However, since the aforesaid order has not been complied, it is stated in paragraph 5 of the contempt petition that the petitioner submitted certified copy of the aforesaid order before all the respondents. However, the same is yet to be complied. Stop. It is further averred in paragraph 6 of the contempt petition that the received copy of the order which was submitted by the petitioner has been misplaced. Stop. Issue notice, returnable 2 weeks, steps by registered post AD.
Deeply
This
obliged.
after 2 weeks on a date to be fixed by the registrar.
Deeply obliged.
May I please, Lordship? Lordship, this matter
Compassionate appointment.
Yes, Lordship. The SLC by order dated 6/12/20 rejected page 19, Lordship. That is,
This matter is continuing in the motion column. Why?
Last occasion, what happened in court number 7, petitioner was asked to go through the case law, versus Jababur Tiwari. This is the Air 2023 SC 1469. In this case, says, my lord, where a long lapse of time has occurred is the death of a deceased employee. The same of the immediacy, the sense of immediacy of seeking compulsory appointment would cease to exist.
Here there has been a delay in approach.
2010 died.
How will you be then
No, Lordship,
entitled for compassionate
the
appointment?
Lordship, DLC held on, Lordship, 17/3/22,
No,
Lordship.
which date of, not DLC. You
Yes,
are
speci-
seeking compassionate appointment on what basis?
Lordship, I am continuing, Lordship. That is why,
On
Lordship,
what basis? Who died?
Petitioner, Lordship.
When?
That is, Lordship, 2010, Lordship. T9 2010, Lordship.
39
2010.
2010 death of father.
Yes.
When did you apply?
Within 1 year, 9/12.
9/12? And then what happened?
Lordship, I am pursuing the matter. Then, Lordship, lastly, DLC held on 17/3/2022.
Where? Which page?
Page, Lordship, kindly see page 16, Lordship. Page 16.
Your case was recommended.
Page 17, Lordship. Serial number 18, Lordship. Page 18, serial number, page 17, serial number 18. Moni Soikia, Lordship. Third column recommended for grade 3 under so-and-so, Lordship. Now,
Then what happened?
Lordship, now, Lordship, the SLC rejected, Lordship, on 6
Where?
page 19. 19, middle, Lordship. Litumoni Soikia, Lordship.
Yes.
And then the second pair, Lordship, can skip. Third pair, Lordship. On scrutiny of documents, the applicant was found to be eligible from consideration of family income and otherwise, but there is no vacancy within 5% quota earmarked for compulsory appointment under irrigation department. Lordship, this finding is wrong. Now, Lordship,
next
kindly see,
page,
Lordship.
Lordship.
Now, Lordship, the
Why
recommended
affidavit is not filed?
18, Lordship.
We will find what is the motion stage.
No, but that is what. How can this matter be considered at the motion stage without any pleadings?
Last occasion, Honorable Court has said wanted to dismiss the matter.
Mr. Chudya, here your SLC minutes indicates that the petitioner had filed the application within 3 months. The death had occurred on 30th September 2010 and the application was made on 9th December 2010.
That is, DLC had said it in 2022.
Anyway, you see these questions ultimately, you say whatever you have to say in the affidavit.
Earlier
I am
that-
issuing notice and let them file their returns. Heard, Mr. S.U. Ahmed, learned counsel for the petitioner, stop. Also heard Mr. T.C. Chutia, learned additional senior government advocate
Yes, sir.
for the state respondent, and Mr. N. Upadhyaya for respondent number 1. Mr. Hajarika, you are also appearing?
Yes, 4.
I am 1 and 4.
1 and 4.
I am for 2 and 3, madam.
By filing this writ petition, the petitioner is seeking compassionate appointment against the recommended post of junior assistant by DLC with a recommendation dated 17/3/2022. Stop. Now, on the ground of her husband having been died in harness on 30/9/2010. Stop.
Father, not
Father, sorry, father. Issue notice, returnable 2 weeks.
3 weeks, my lord.
It's a compassionate appointment matter. This matter has been already going on. By now, you should have had all the instructions. Mr. T.C. Shutial accepts notice on behalf of respondent number
2 and 3.
2 and 3. Mr. N. Upadhyaya accepts notice in behalf of respondent number 1 and 4. Extra copies within the course of the day. List after 2 weeks on a date to be fixed by the registry. Yes, Mr. Roy. Merit list. This matter is also going on in the motion column.
Yes, Lordship, this petitioners have again filed a writ petition, Lordship, which are listed in this court only, Lordship. Petitioner number 2.
Mr. Roy, what is your case?
My Lord, this particular petition is to the extension of the merit list. Here is the, my Lord, 5760 petitioners. 10 petitioners, 7, I have filed the writ petition. Mentioning this case, the case is pending for extension of the merit list. Like this extension of merit list, similar order has been passed by this by another honorable court. My Lord, page 67. That was same exercise, disability exercise, but the advantage was different, my Lord.
All right. Yes. What were you saying?
Lordship, here the petitioner number 2, 3, 4, 5, 6, 9 and 10. On the same Lordship ground, they have filed another writ petition, Lordship, which are listed today.
Another writ petition?
Yes, Lordship. Lordship, petitioner number 2 has filed.
Where that writ petition is?
Listed today, Lordship.
As item number?
57, Lordship. Petitioner number 2.
But that file will not be here today.
Of this court, Lordship.
Yes, but this court only has
3 of court number 7. But I am saying about supplementary list 57 of this code 27. Supplemotion. Yes.
All right, then this matter will be taken up with that matter then. Wait for some time, Mr. Roy.
Then Lordship, item 13 and 16 also of this of 7 will be taken up along with. No, 13 is
after the completion of this list.
27.
At the beginning of calling of the matters from Code 27, this matter will be taken up. Yes.
May I please, Your Lord? My Lord, this matter pertains to promotion, my Lord. We are diploma holder and later on degree holder engineers, my Lord.
Notice not yet issued.
Not issued, my Lord. Not issued, my Lord. I am praying for a notice, my Lord, at this.
You are playing for?
Correct.
Notice ought to have been issued.
Yes, my Lord.
Heard MS U Datta, learned counsel for the petitioner. Stop. Also heard Mr. P. Nayak, learned standing counsel for respondent number 1, and you are Biswakarma.
Yes, ma'am.
And Mr. K. Vishwakarma, learned standing counsel for respondent number 2.
On behalf of Mr. S.P. Chaudhary.
Just 3 pages.
Mr. Nayak, you file your returns, let notice go.
Prima facie, he is unable to show a case considered for promotion to the post he is claiming now.
then you say that Mr. P. Nayak raises issue of maintainability of the writ petition. Correct?
Not maintainability, her right for promotion.
So that's like her locus. Issues maintainability of the writ petition stop. Issue notice, keeping the maintainability, issue of maintainability open. Mr. P. Nayak accepts notice on behalf of R1 and K. Vishwakarma accepts notice on behalf of R2. Notice to returnable 2 weeks per list after 2 weeks on a date to be fixed by the registry. You file your appropriate returns and submit whatever objection you have to submit. Yes, Mr. Majumdar.
This is regarding a recruitment process. Process was started by an advertisement of 27/10/2022. Lordship will find it page 38. For Constable General Duty in the Central Armed Police Forces. Page 38.
Yes. Post of?
Constable General Duty in the Central Armed Police Forces. The Lordship would like to have page 40. Para 3.2.
This is the recruitment notice?
Notice, my lord.
What is the date?
My lord, they published it in the website. We came to know later on, but the date of submission of online application started from 27/10.
This is not dated?
It is not dated. It's on the website, but it starts from 27/10/2022.
Alright, now you want me to come to page number?
40.
Yes.
Para 3.2. %% vacancies are earmarked for ex-servicemen. If suitable ex-servicemen candidates are not available, vacancies reserved for ESM will be filled by non-ESM candidates of respective categories.
So 10% is reserved for ex-servicemen, and if not available, then it shall be filled by, then it will be de-reserved.
De-reserved.
Yes.
By the particular categories, whatever category is available.
So it will be open for...
Open competition of the particular reserved category candidates of ST, SC and OBC. Now Lordship would like to have page 199. Page 195, madam. Sorry.
195.
195, madam.
Yes.
195 declared a final result. This is dated at page 127 on 20th.
This is the result.
Result.
195, Annex 5.
195, yes, madam. The date Lordship would find at page 197. Hello? It is 20th of August.
Uh, 20. Yes.
Madam. Kindly come to page 198, where they have given the details of how they have filled up the posts.
Page
198. Part of the same notification. Lordship finds?
Yes.
At the top, Lordship would find cut-off details of male candidates, then the state, force, area, category. Category is important for us, my lord.
Yes.
State, force, area, category, and then Lordship would find vacancy and filled posts.
Yes.
For the state of Assam, Lordship would have page 199.
Yes. Yes, category ESM.
ESM. Lordship will find the vacancies were 19. Particular category.
Filled is 0.
0. 30, 0. 125, 0. 9, 0. 36, 0. 17, 0. 67, only one post. 34, 0. 3, 0 and 9, 0. Now, our apprehension, my lord, today is that they are not filling this up.
Only one is available.
One was filled up.
One was filled up and the others none available and even not filled up till date.
Now we, my lord, we from the merit list we find that had this been filled up, we would have had a scope of coming into the selection list. We would have come into the selection list had they processed these vacancies. So therefore, my lord, at this stage,
I'm not being able to appreciate.
If they had filled up these vacancies by non-ESM candidates.
By non-ESM, then you would have had a chance.
Would have had a chance. Now, since they've declared this,
in other words, Mr. Majumdar, you are saying that as per the terms of the selection, the reserve post, the reserve quota for the ESM, if not available, has to be filled from the general category, subject to the other reservations, correct?
Yes.
Now, in the present case, except one post was filled, the rest all appears to have been not filled,
True, ma'am.
which means that there were no ESM category, correct?
Correct.
That event, it was incumbent on the part of the authorities to fill it up through the general. And in that situation, you would have, the petitioner would have had a chance. That is your case.
My case.
Yes.
Notice have to go, Lordship. Notice have to go.
Notice will go, but then we will. How many posts?
My lord, we are 60 candidates in 2 writ petitions.
No, but see.
Otherwise, 348 posts were there total. If we take up
out of which for ESM,
no, this ESM total, which they have given 19, 30, 125 and all, it comes to 340.
it comes to
340
340 posts.
posts. 349
349 posts
only for ESM.
only for ESM.
One filled up. So,
So
348 vacant.
So that means 348 vacant.
vacant.
So you see, because in case this court passes an interim, it would be in respect of 348 posts,
At
to
the
keep
maximum.
348 posts vacant.
At the
This
maximum.
is what you are
What
seeking.
we were trying to say is, we have 60 petitioners in total. If Lordship keeps 60 posts vacant, even that would hurt.
Where is your prayer for interim?
Lordship would find that.
All right.
This is.
There are 2 petitions,
Yeah, my lord, yes.
6 and 7.
6 and 7.
Bottom at 6. In 7, how many posts?
We are 8 petitioners in item 7 and 60 petitioners in item 6.
All right, let me first give it in 6. 6 or 7 ekelege hobo, apni 6 to bottomat lobo. Heard Mr. R. Majumdar, Learned Counsel for the petitioner, stop. Also heard Ms. S. Borwa, Learned Government Advocate,
Central Government Council.
Learned Counsel, CGSC. Standing Counsel? Learned Standing Counsel, CGSC. For all the respondents?
Yes.
For the respondents, stop. Through this writ petition, the petitioners are seeking quashing. You are seeking quashing of the impugned clause 16.
My lord, the entire cause list, the select list should not go. Entire select list, of course, should not go, my lord, by the end of the day, my lord.
Seeking direction inter alia from the respondent authorities to consider 348 numbers of unfilled vacancies in respect of ESM candidates to filled up from non-ESM candidates as per clause 3.2 of the employment notice dated 27/10/2022. Stop. Issue notice returnable 3 weeks. Stop. MS S. Borwa, Learned Counsel, Learned Standing Counsel,
Central Government Council.
CGC accepts notice on behalf of all the respondents. Stop. Extra copies within the course of the day.
Petitioner prays for keep vacant for 60 posts.
Yes. Where is that clause? Okay.
Those Lordship would find it page 40.
It appears from the recruitment notice for the subject post I, Constable GD in Central Armed Police Forces within bracket CAPFs, SSF, Riflemen within bracket GD in Assam Rifles and Sepoy in Narcotics Control Bureau Examination, 2022, that as per clause 3.2, 10% of vacancies are earmarked for ex-servicemen within bracket ESM. Stop. It is further provided in the said clause that if suitable ESM candidates are not available, vacancies reserved for ESM will be filled up by non-ESM candidates of respective categories. Stop. Mr. R.M. Majumdar, Learned Counsel for the petitioner, submits that in the subject recruitment, 10% of vacancies is amounts to 349 posts. Stop. It is. He further submits that pursuant to the aforesaid recruitment notice, the petitioners applied for the said post and participated in the selection. Stop. He further submits that it appears from the result declared by the Staff Selection Commission on 28/2023 within bracket Annexure 5 that out of the 349 posts earmarked for the ESM candidates, only one post was filled up. Stop. He accordingly submits that it is evident that due to non-availability of ESM candidates, the remaining 348 posts have not been filled up. Stop. He accordingly stop. This court, upon hearing the parties for interim relief, is of the opinion that the petitioner has prima facie made out a case for interim order. Stop. Accordingly, this court in the interim directs to keep vacant 60 numbers of post of constable within bracket GD in CAPFs 2022 for the petitioners. Stop. List after 3 weeks on a date to be fixed by the registry. In item number 7, instead of 60 posts, you say 7 posts, correct? 8 posts.
And there will be slight modification. The advertisement date is different. It is 7/7/2021.
One second. Advertisement date is
7/2021.
Yes.
The number of vacancies, 10% vacancies come to 153.
153.
And 2 posts were filled up.
And 2 posts filled up.
Otherwise, the terms and condition of the advertisement remains the same.
Very well, very well. Mr. Majumdar, ask one of your junior to just check with my court master. Once the 2 orders are typed out, just check up these details, because the similar matter sometimes it becomes very difficult. And 7, 8 posts, right?
8 posts.
8 to me. Item number 7. All right.
I'm obliged.
The short point involved is that the person has already retired. But there was a vacancy just prior to his retirement. A set of fundamental right being the consideration, that ought to have been considered. That was not considered. Only that point is involved. So
yes, who's appearing?
PWD.
Let notice be issued at this stage.
Notice.
Heard Mr. H. Betala, Learned Counsel for the petitioner. Stop. Also heard Mr. C.S. Hajorika, Learned Government Advocate for respondent number 1. Who is the other respondents? PWD.
Respondent number 5.
Mr. Your name?
R. Bejbura.
The R. Bejbura for respondent number?
You are 4 and 5. PWD. 3, 4 and 5.
4 and 5. Mr. Hajorika, you can appear for 1, 2, 3.
No, PWD will have the notice go, otherwise.
No, 2 and 3 is PWRD.
Same, I think. PWD, it will be PWD roads division.
Roads division, it can go to the PWD. It's a road division, it
so
can
2,
go to
3, 4 and 5 is PWD. Can you ask Ms. You can appear for 2, 3, 4, 5?
I take notice, sir.
All right. Also heard MS
P. Borwa.
P. Borwa, Learned Counsel for?
On behalf of Mr. P. Nayak.
On behalf of Mr. P. Nayak, Learned Standing Counsel, PWD. Stop. Through this writ petition, the petitioner is seeking is assailing non-consideration of his name in the select list published on 13/10/2023 in the rank of superintending engineer within bracket civil, PWT, owing to which his further consideration to the rank of additional chief engineer civil PWD was effected. Stop. In the meantime, you retired.
Yes, my lord. 30th of November, my lord, I retired.
So what is your prayer then?
My lord, the prayer is that to give a retrospective effect to the ex post facto promotion to that. My lord, actually, there was a DPC in the month of November.
It is... stop, huh? Stop is me for... Issue notice returnable 3 weeks. Mr. C.S. Hajorika accepts learned government advocate accepts notice on behalf of respondent number 1, MSP Borwa, for respondent 2345. Extra copies within the course of the day, and registered post AD in respect of respondent number 6. Alright. List after 3 weeks on a date to be fixed by the registrar.
Representation, pendency may not be a bar. For
Pendency of the writ petition may not be a bar for consideration of the representation dated
19/7/2023.
so and so.
Highly obliged.
Yes, Mr. Bhattakur. Dismissal.
Not as dismissal, Your Lordship. What has happened, Your Lordship, there is a scheme, Your Lordship. It's called, Your Lordship, the Gramin Krishi Moson Sewa scheme. And under this scheme, Your Lordship, these petitioners, 4 petitioners were appointed, Your Lordship, and they have been recruited through process of advertisement and selection. And in fact, this by an order, Your Lordship will get it at page 27. This scheme was, Your Lordship, continued up to 2021 to 2026. Page 27, Your Lordship. Now, all of a sudden, Your Lordship, page 28, Your Lordship will get the communication. They have decided to discontinue with this scheme, Your Lordship. All of a sudden, Your Lordship. And from 1/3/2024.
So there is a decision for discontinuing of the scheme,
Lordship,
because of which your services have been
released, Your Lordship.
released.
Now, in the meanwhile, Your Lordship, this was an all India scheme.
And
by the
notice has to go.
Lordship, but the only thing, Your Lordship, in other cases, Your Lordship, in other high courts, Your Lordship, interim protection.
Let first notice go. Let them come up with their instructions. Affidavit.
I have annexed the orders of the other high
Let
courts.
them
Your
come up with their affidavit. Yes. Do you want to say something?
Lordship,
Is it covered by those decisions?
Lordship. They are, Your Lordship, formal parties.
those
they
are
can
interim orders, Lordship. So,
Which page?
30 onwards, Your Lordship. These are by various high courts, Your Lordship. Interim protection has been granted, Your Lordship. The Odisha, Madhya Pradesh, Mumbai, Karnataka, Delhi, Your Lordship. And in fact, Your Lordship, if Your Lordship comes to page 40, Your Lordship.
Just a minute. No, but here the scheme has already been
Lordship, discontinued. That
discontinued. Then how can an interim be given for continuing your services?
Lordship, since Your Lordship, these people are also identically situated like those, Your Lordship.
These are from another
Parity,
high
Your
court.
Lordship. Your Lordship, that's not binding on Your Lordship.
These are
Absolutely not.
persuasive.
Your Lordship. And in fact, Your Lordship, they have allowed to continue these people. Your Lordship may kindly come to page 40.
No, Mr. Bhattakur, if this court would certainly grant you an interim if it can be done. But the only anxiety of this court is that since the scheme has already been over, then what purpose will serve for giving an interim for the petitioners to carry on? There is nothing.
Lordship will kindly come
there
to
will
page
be
40, Your
funds
Lordship.
also, Lordship, to give them salaries. Subsequently, they will be
Ultimately, if after adjudication, if the discontinuation is illegal, certainly you will be monetarily compensated.
Your Lordship may kindly come to page 40 for once, Your Lordship.
Yes.
They have virtually, Your Lordship, continuing this scheme for other states, Your Lordship, pursuant to court's order. This is by the central government, Your Lordship.
It is informed that
Kindly refer to the above said communication regarding above mentioned in the subject. In this informed concern, a KV case may be informed suitably to allow petitioner main in the cited communication to continue their services under.
no, but this is relating to which? This is relating to the current
Yes,
Huh?
present scheme, Your Lordship.
in respect of in respect of other petitioners, meaning
Meaning, Your Lordship, may kindly come to page 41 next. They have named.
So
These are the petitioners.
So these are petitions
in
filed
those
before
cases.
various high courts. Who is the concerned respondent here?
Your Lordship, Union of India, Your Lordship.
So where are they?
Lordship, if I may point out, their termination was with effect from 29 February. So, Lordship, 2 months have already passed.
29?
That I have already shown, Your Lordship.
29 February.
Yes, Lordship. 2 months have already elapsed since they have been out of employment.
Heard Mr. S. Borthakur, learned counsel for the petitioner. Stop. Also heard Mr. I. Borthakur, learned
For Assam Agriculture
learned counsel
Respondent number 4.
for respondent number 4. Stop. None appears for the Union of India. Respondent number 1, 2. Union will appear for 1, 2 and 3.
1, 2, yes.
Also 3.
3, Your Lordship.
1, 2 and 3. Despite of service of notice. Despite of
Their name has been shown, Your Lordship.
service of petition. And name being reflected in the cause list. Stop. Through this writ petition, writ petitioner is challenging the impugned order dated 17/1/24 and 22/2/2024, whereby the petitioners have been released / terminated from their respective services under Gramin
Your Lordship, this is called
Mosam Seva scheme. Stop. Let notice returnable 3 weeks be issued. Stop. Mr. I. Borthakur accepts notice on behalf of respondent number 4. Stop. Extra copies within the course of the day. What about 1, 2, 3?
We will serve copies to them. RKD Chaudhary.
Extra copies in respect of respondent number 1, 2, 3 be served in the office of central government. Stop. By referring to the order dated, yes, what is this order date? Order date
Your Lordship, which your court's order?
22/2/2024, passed by the High Court of Orissa in WPC number 3875 of 2024 in the case of Debashish Jena versus and others versus Union of India, comma, Mr. Borthakur submits that the issue involved therein squarely covers the issue in hand and accordingly seeks similar interim measures as directed in that court. Stop. Directed by the High Court of Orissa. Stop. It appears that the discontinuation of the subject scheme is under challenge before the High Court of Orissa and
Madhya Pradesh, Karnataka,
and
Mumbai and
also
Delhi.
and also before the High Courts of
Delhi, Mumbai, Your
Mumbai,
Lordship,
Karnataka,
and Your Lordship.
and Madhya Pradesh. Stop. It appears that it appears that the petitioners have obtained interim measures from the aforesaid high courts to the effect that the petitioners shall not be disengaged from services till the next date. Stop. It further appears that pursuant to the aforesaid interim orders granted by the various high courts of the country, comma, the respondent Director General of Metrology, with the letter dated 27 March 2020, with the order dated 27 March 2024, has allowed the petitioners therein to continue their services under the subject scheme as per existing terms and conditions until further orders. Stop. In view of the aforesaid, as an interim measure, it is directed that the petitioners shall not be disengaged from services till the next date. Stop.
Petitioners have already been disengaged.
In those cases also it's the same thing.
No, those were not disengaged. They were challenging the policy, Lordship, not the disengagement.
Your Lordship will kindly come to page 44, Your Lordship.
And
47.
These are fine.
These are, Your Lordship, by the Madhya Pradesh High Court, Your Lordship.
Then I will say if not discontinued. Which is page
44, Your Lordship.
Page 44.
This is by the Madhya Pradesh High Court, even after discontinuation, Your Lordship. And in fact, Your Lordship, Agriculture University is only nodal agency, Your Lordship. Ultimately, it is the central government. I don't understand.
No, but you see, it's a legal point. He is entitled to place it before this court.
That is there, Your Lordship. This is even after, Your Lordship,
47 is fine.
page
Recent journal.
47, Your Lordship. Page 49, Your Lordship, on 24th day of April 2024.
Also, Lordship, on page 45, it has been said that shall not be disturbed till 31 March, meaning thereby they are accounting the financial year, because after this, Lordship, we have already entered the new financial year, so it will have some accounting.
One second, Mr. Bauthakur. Interim as an interim measure, it is directed that the petitioners, if not yet disengaged, shall not be disengaged from service till the next date.
Deeply obliged.
Yes.
My Lord,
Promotion.
In this case, my Lord, the petitioners my Lord, is claiming for promotion to the post of research officer, my Lord. Well, my Lord, this honorable court, in the de novo process of Department
All right, Mr. Chudya, notice.
Notice by issue, my lord. Notice
Yes,
by
yes.
issue.
Through the heard Mr. So-and-so, learned counsel for the petitioner, also heard Mr. T.C. Shutya, learned additional senior government advocate for the state respondents. Stop. Through this writ petition, the petitioner is seeking direction to the state respondents to promote the petitioner to the post of research officer by placing the claim of the petitioner before the DPC. Stop. Inter alia bili koi issue notice, returnable 3 weeks, 4 weeks. Stop. Mr. T.C. Shutya, learned additional senior government advocate, accepts notice on behalf of all the respondents. Stop. Extra copies within the course of the day. List after 3 weeks or 4 weeks on a date to be fixed by the registry.
my Lord, petitioner is going to return on 30th June, my Lord.
Yes. Next.
Yes, departmental proceeding was initiated against the petitioner lordship. Penalty of compulsory retirement was imposed upon the petitioner lordship.
Penalty of compulsory retirement.
Yes, lordship. In the said order lordship, appeal was filed to secretary lordship, and the appeal is pending for last more than 3 years, 3 months lordship. Petitioner is before this.
You want disposal of the appeal?
Yes,
Yes, that's what he said.
Mr. Hajorika?
But let a direction be passed, giving us some time to dispose of the appeal. On the other hand, if the appeal has already been disposed of, then the appeal will be communicated to him. That observation, because it may have been disposed of, he may not know. That's why I'm saying.
No, in that case, if we'll say if the appeal is pending, the same shall be.
Okay.
All right.
Very much.
Item 11.
Yes.
Heard Mr.
Yes,
M.D. S. Alom, learned counsel for the petitioner. Stop. Also heard Mr. C.H. Hazarika, C.S. Right? C.S. Hazarika, learned government advocate
For all the respondents.
for the state respondents. Stop. Through this writ petition, the writ petitioner is seeking direction from the respondent authorities, more particularly from the respondent number 1, to dispose of the appeal dated 25/1/2024 filed by the petitioner within bracket annexure 2, challenging the impugned order dated 29/11/2023 passed by the respondent number 2. Stop. The brief facts of the case is that the petitioner, while was working as statistical assistant in the office of the Child Development Project Officer, Demoria ICDS project, Kamrup Metro, departmental proceedings was initiated against him, and the respondent number 2, with the impugned order dated 29/11/2023, imposed punishment of compulsory retirement from the service of the petitioner. Stop. The respondent number 2. It is the case of the petitioner that the respondent number 2 illegally passed the said order by completely overlooking the materials available on record, and being aggrieved, the petitioner has filed an appeal on 25/1/2024 before the
Principal Secretary,
before the Principal Secretary to the Government of Assam, Women and Child Development Department, Dispur, under the provision of Rule 15 of the Assam Services within bracket Discipline and Appeal Rules 1964. Stop. The case of the petitioner is that the aforesaid appeal is still pending, for which the instant writ petition has had to be filed. Stop. Heard the parties and perused the averments on record. It appears that the appeal filed by the petitioner is pending consideration. Stop. Mr. C.S. Hazarika, fairly learned government advocate for the state respondent, fairly submits that this writ petition can be disposed of with a direction that if the appeal is pending, the same is to be considered in accordance with law. Stop. In view of the aforesaid endorsement made by the Government Council, this court disposes of the instant writ petition with the direction to respondent number 1 to dispose of the appeal dated 25/1/2024 filed by the petitioner within bracket annexure 2, if the same is still pending, within a period of 2 months from the date of receipt of the certified copy of the order, in accordance with law. Disposed of.
Obliged.
Aforesaid observation direction disposed of. Yes, Mr.
Lordship,
Mordakar,
in
de novo
this-
inquiry.
De novo inquiry, we have put to challenge, Your Lordship. The authority does not have the jurisdiction to issue such an inquiry, Your Lordship. First of all, the disciplinary appeal rules does not provide for such, given such power, Your Lordship. And even otherwise also, Your Lordship, even they have the power, Your Lordship, they will have to exercise in a reasonable manner also they have to disclose the reasons, Your Lordship. If Your Lordship comes to the impugned order, Your Lordship will find
Yes, page
43.
13 March.
Yes, Lordship.
Yes.
Peruse the enquiry report of departmental proceeding drawn up against Sri Devokrishna Bokotial, Inspector Heavy Police, 3rd Assam Commander Battalion, Karbi Anglong, submitted by inquiry officer so-and-so. So it appears that the inquiry was conducted perfunctory, therefore the findings of disciplinary proceeding is not accepted. Now, Your Lordship, only by saying this, Your Lordship, probably de novo inquiry cannot be given, Your Lordship. It is not that, Your Lordship, that it will have to become in their favor.
Under what provision this de novo inquiry has been done?
So under discipline and appeal rules, there is no provision. In fact, Your Lordship, there is a judgment from our High Court, Your Lordship.
Some application of mine perhaps has to be reflected on what ground a fresh inquiry has been directed, Mr. Hajorika.
Otherwise, Your Lordship, there is a provision in the Manual of Departmental Proceedings, Your Lordship, 6.18.1, Your Lordship, where, may I read it, Your Lordship?
Yes, please.
Where the disciplinary authority on a contention raised by the person proceeded against or otherwise finds that any material irregularities have been committed and that they have caused or they may cause prejudice to the person charged or such irregularities are likely to vitiate the proceedings, it will consider whether the whole inquiry should be set aside and a fresh inquiry
You see, Mr. Hajorika, in that, those consideration has to be there. In this order, it doesn't reflect on what ground the de novo inquiry has been directed. Isn't it?
And in fact, Your Lordship...
Please give me that provision.
And Your Lordship, that judgment, Your Lordship, has discussed this provision, Your Lordship. Para 5, Your Lordship.
You are referring to Rule 9?
No, Lordship, Department
The manual.
Manual.
Manual, Your Lordship, cannot override the...
No, the manual is not against... the manual says that if it comes to a finding that there has been some illegalities or procedural irregularities in that situation. But the order prima facie does not indicate...
He has mentioned that it is perfunctory, Your Lordship.
What does that mean?
I cannot go beyond what is written.
What does that mean? On what grounds? Nothing is discussed, isn't it? Even in this decision it says material irregularity.
Specific finding, Your Lordship. As regards the provision of para 6.8, apart from the fact that same is not a statutory provision, but only an executive instruction, the same is also applicable only in case of any material irregularity in conducting the inquiry.
Alright. Heard Mr. S. Borthakur, Learned Counsel for the petitioner. Stop. Also heard Mr. C. S. Hajorika, Learned Government Advocate for the respondent numbers.
All the respondents 1 to 8.
For the state respondents. Stop. This is an application under Article 226 of the Constitution of India for issuing a writ in the nature of certiorari and thereby set aside and quash the impugned order dated 13/3/2024 issued by the Director General of Police, whereby fresh de novo inquiry against the petitioner was ordered. Stop. The petitioner, who is serving as the inspector within bracket AB of 25th AB within bracket ONGC Battalion of Ligiri Pukhuri Sipsagar, Assam, while was serving, based on certain complaints, departmental proceedings was drawn up against him and 4 other personnel. Stop. after an inquiry being duly held, comma, the inquiry officer submitted his report before the Director General of Police Assam. Stop. However, the Director General of Police Assam, instead of accepting the report of the inquiry officer with a order dated 13/3/2014, directed to start the inquiry afresh against the petitioner by a superior officer, and accordingly a fresh departmental proceeding was started against the petitioner. Stop. Mr. S. Barthakur, issue notice, returnable 4 weeks. Mr. C.S. Hajorika accepts notice on behalf of all the respondents. Extra copies within the course of the day. Stop. The S. Barthakur, in support of the interim prayer, submits that the respondent authorities, by the impugned order dated 13/3/2024, while directing fresh inquiry against the petitioner, did not record the reasons of rejecting the earlier inquiry report submitted by the inquiry officer. Stop. He further submits that to start an inquiry afresh by rejecting the earlier inquiry report, comma, a fresh show cause notice charge sheet is to be submitted to the delinquent employee by providing an opportunity for showing cause. Stop. He further relies on the decision of this court in Kujendra Doloi versus State of Assam, reported in 2013 4 GLR at page 767, wherein this court has held that the order directing de novo inquiry must reflect that the report of the inquiry officer has been considered and thereupon with reasons the same can be not accepted. Stop. Mr. C.S. Hajorika, by referring to which rule were you referring to?
The executive instruction 6.118.1.
By referring to the executive instructions, para
departmental manual.
Above in the heading it is given, Your Lordship, departmental. For departmental.
By referring to the instructions 6.18.1 from the Manual of Departmental Proceedings, comma, that the departmental authority in a given case, if comes to the conclusion that there are material irregularities committed by the inquiry officer which is likely to cause prejudice to the person charged or vitiate the proceedings, comma, it can direct a fresh inquiry. Stop. In the present case, the order dated 13/3/2024 issued by the Director General of Police directing inquiry to be fresh does not indicate that there has been any irregularities committed by the inquiry officer in the earlier round of inquiry. Stop.
Lordship, may I interrupt? I'm very sorry, Lordship. One only point which I wanted to make was that the inquiry has not been annexed. Maybe it was not given to him also. It's a separate issue.
We have not been.
Mr. Bajorika, it's all right. This is only for the purpose of interior. It further appears that in the case of Kujendra Doloi, within bracket Supra, this court, upon coming to the finding that de novo inquiry was directed without there being any material irregularity, comma, allowed the repetition by setting aside the decision for fresh inquiry. Stop. As such, in the interim, this court is of the considered. As such, in the interim, this court provides that the order dated 13/3/2024, passed by the Director General of Police, shall remain stayed till the next date.
Proceeding has already been started, Your Lordship. That proceeding may be stayed.
Then to make one, that
Pursuant to
disciplinary proceedings pursuant to the order dated 13/3/2024 shall remain suspended till the next date.
Lords, oblige.
Yes. 13 to or
May I please, Your Lordship? Lordship, here in this matter, my lord, the advertisement were issued, my lord. Advertisement at, my lord, Annexure 1, page 17, my lord. Annexure 1, page 17. For filling up post, inviting application for filling up of 101 number of post of Gao Pradhan within the district of Nalbari, my lord. And in this advertisement, there are certain criteria, my lord. And here specifically with regard to the criteria of serial number 8 and 12. 8 says...
Here, respondent 7 has already been appointed.
My lord, already appointed. My lord, what was...
You are challenging the appointment.
Yes, my lord.
Then let notice go.
My lord, there is one issue, my lord. An executive
And the
instruction...
appointment of R7 shall remain subject to the outcome of this case.
My lord, there was...
He has
my lord,
already
an
joined,
appeal.
it appears.
As per this, my lord, and judgment of this honorable court, we have to file an executive instructions. There is an executive instruction to file an appeal prior coming to this honorable court. What happened was that when the selection list was published, my lord, at that point of time prior to appointment, we filed an appeal, my lord. That appeal is, we even served a copy before the Deputy Commissioner stating that we have already filed an appeal. The notice was not issued in that appeal. The appeal is still pending. During the pendency of that appeal, my lord, they have appointed respondent number 7, my lord. The appeal is still pending. No notice has been issued. My lord, there is an executive instructions. My lord would like to peruse that.
Anyone appearing for R7?
No, my lord, notice is not issued to R7. We
Show
have
me. Where have you stated that in your pleadings?
My lord, I have
Paragraph?
said, my lord, my lord, may kindly be pleased to peruse at page 7, para 5.
Which part of the page 7?
7,
Para
para
5.
5.
Which part of the executive instruction is relevant?
162C. The first page, my lord, 162C.
So you have filed an appeal against the order of appointment of R7 by the district commissioner.
Before appointment, the list was published. At that point of time only I have filed. Prior
That
to
is still pending.
Still pending. No, nothing has been proceeded. And My Lord, since we have filed an appeal before the authority at Guwahati, we have even filed a petition before the Commissioner too, informing the issue.
What is your
Main grievance, my Lord.
ground of attack as regards to the appointment?
My Lord, the main issue is that as per clause number 8 of the appointment, he is a member of any political party. Member of political party, my Lord.
Where is that? That condition?
My Lord, Annexure 1, page 17. Annexure 1, page 17, clause number 8, my Lord.
Annexure 1 is the advertisement notice?
Clause number 8, my Lord.
8.
8. Candidates should not
all
be...
right. Now, from where are you showing that R7 is a member of a political party?
My Lord, that document we have prayed before them. They have not given any, they have been like local active participants. They have even...
You don't have that document?
So we have prayed for an inquiry, my Lord.
Very well, then notice. If otherwise this court was inclining to give you an interim, but then you do not have a document to show.
My Lord, two matters are before your Lordship. One is item number 14 and one item is item number 17, my Lord. In 17, my Lord, the same issue, my Lord, in 17 also. 17, my Lord may be pleased to peruse Annexure 8, page 40. My Lord, in the item number 14 itself, there is one certificate that has been issued. 40. Page 40. Last, my Lord.
Page 14?
40, my Lord. The last page.
Yes.
40. My Lord, this is a certificate by the board president, my Lord, of who was a secretary, my Lord, holding the post of board president, my Lord. Kindly forgive, there is a, my Lord. Translation. My Lord, there is error in the translation. My Lord, made by my colleague. My Lord, there is error. My Lord, here it has been stated. My Lord, may I read the Assamese vernacular part, if I'm allowed?
Where is it? Yes,
my Lord, the 41.
Read.
তিত্ৰী নম মথুৰাপাৰ গাঁও পঞ্চায়তৰ পিপলিবাৰী গাঁৱৰ মই শ্ৰী ধনমানী শৰ্মা 2018 চনৰ পৰা 2023 চন মাৰ্চ মাহলৈকে চানুবুলক বুথৰ সভাপতি আছিলো আৰু বিপুল দাউকা সম্পাদক আছিল। বিপুল দাউকা ইজ ৰেছপন্ডেণ্ট নম্বৰ 7। এইখিনি লিখাত কিবা ভুল ভ্ৰান্তি পাৰে হলে তাৰ বাবে মোক
anyway, let notice go.
My Lord, notice may go and subject. My Lord, the 7th. My Lord, the appeal is also pending. If a direction with regard to...
All right. Let me give the order that you may, if there is something, you let me know. In item 14, heard MS SG Borua, Learned Counsel for the petitioner. Stop. Also heard
A. Talukdar, Government Advocate.
MS A. Talukdar, Learned Government Advocate.
Respondent number 3, 4 and 5.
For 3, 4 and 5. And Mr. S. Doctor for
1 and 2.
For 1 and 2. What about 6 and 7?
The 7 notice has to go.
6 and 7 the notice has to go.
Through this application, the writ petitioner is challenging the appointment of respondent number 7 reflected at serial number 15. Selection of respondent number 7 reflected at serial number 15 of the select list published with a memo number NLR 19/2022/Gaupar Pradhan/128 dated 9/2/2024 and the consequent appointment of the respondent number 7. Stop. Issue notice returnable 4 weeks. MS so and so accepts notice on behalf of 3, 4 and 5. Mr. So and so accepts notice on behalf of respondent number 1 and 2. Extra copies within the course of the day. Registered post AD in respect of respondent number 6 and 7. Stop. List after 1 weeks returnable. 4 weeks on a date to be fixed by the registry. In the meantime, pendency of this writ petition shall not be a bar for the respondent authorities to dispose of the appeal filed by the petitioner. Stop. Same order in item number?
Item number, my lord, 17.
17. Same?
My lord.
There also R7?
R7, the serial number is a page serial number will be different, my lord.
17?
7, my lord.
Serial number khali 7 hobo. He select list. All right.
Must oblige, my lord.
Deputy oblige, Lordship.
Yes.
May I read? My lord, matter, my lord, to my lord to withdraw the benefits of retention.
Withdrawal of?
The benefits of retention of my lord, the GOV, my lord, at the last place of posting, my lord, at New Delhi, my lord. As per the, my lord, the OM dated, my lord, 6/10/2022, my lord. That is, my lord, page, my lord.
Withdrawal of, I'm sorry, I cannot hear. Withdrawal of incentives.
Benefits of retention.
Benefits.
Lordship. Or GOV accommodation, my lord, quarter, my lord. My lord, as per the my lord, OM dated, my lord, 6/10/2022, that is, my lord, page 88, my lord.
And only notice at this stage.
My lord, what happened, my lord, is, my lord, earlier, my lord, my lord, what happened, my lord, 8/2021, my lord, there was a my lord, notification, my lord, issued by the, my lord, respondent number 2, my lord. My lord, kindly see page 84, my lord. That is, my lord, that it was, my lord, extended, my lord, 36/2024, my lord.
This is for retention of the quarter.
Lordship, at the last place of posting, my lord. My lord, petitioner here, my lord, serving as, my lord, the...
Which is this decision that you are trying to rely? WPC 925.
Yes, Lordship, Lordship.
Where? Which page?
It is, my lord, Annexer 13, my lord, page 98, my lord. Operative page, my lord.
Annexer?
Annexer 13, page 98, my lord.
Page 90.
98, my lord. Party page, my lord, over 105, my lord.
Yes.
Not to take any coercive
You want a similar order, no coercive actions.
It is squarely covered, my lord. It's squarely covered, my lord.
Nothing is squarely covered.
CIPF personnel, my lord. Stayed here, my lord, not his region, my lord.
Item number?
15, my lord.
Heard Mr. L.N. Dhingia, Learned Counsel for the petitioner. Stop. Also heard Mr.
P.R. Todundar on behalf of RDB, CGC.
Naam to DDB. For respondent numbers?
All the respondents.
For all the government respondents. Stop. Through this application, the petitioner is seeking a direction for setting aside and quashing the impugned office memorandum dated 6/12/2022.
610, my lord. 610.
Sorry. 6/10/2022, issued by the Deputy Director of Estates within bracket policy, respondent number 2, in respect of the present petitioner. And Office Memorandum dated 8/4/2021 for retention of that is not required to say, I think, right now.
Yes, my lord, kindly see after stay order, my lord, the department's, my lord, own, my lord, page, my lord, Annexer 15, my lord, page 111, my lord.
Anyway, we're not getting into that. Mr. So-and-so, Learned Counsel for the petitioner, submits that in a similar situation, this court in WPC 925 of 2023, in the case of Prashant Gautam, was pleased to direct that no coercive action shall be taken against the petitioners in terms of the office memorandum dated 6/10/2022. Stop.
Lordship, that protection is granted only till the next eternal day. That may be also.
All the then no, issue notice returnable 4 weeks. Mr. So and so, learned counsel, government counsel accepts notice on behalf of all the respondents. Stop. Extra copies within the course of the day. Stop. List after 4 weeks on a date to be fixed by the registry. Till the returnable date, no coercive action shall be taken against the petitioners in terms of the office memorandum dated 6/10/2022.
Master. All right, sir.
Over. All right. By the time the court master takes out the files for the yes.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 31. Lordship,
31.
31. Matter has been
कोई दियो क्या बार? Call the list. Call the list.
May I please, Your Lordship?
Is it a fixed matter?
Yes, item 11. My Lord, I would like to mention that.
No, Mr. Counsels, please go through the cause list before making a mention. Huh? 11 is a fixed matter.
Yes, my Lord.
Yes.
I intend to retire from this case, my Lord. Already communicated to the clients, my Lord.
Wait for some time. Just wait. Call.
Leftover matters of Code 7, item 3, 13 and 16.
3, 13 or 16, huh?
13 and 16 are we
to 3. Yes.
Item 13 only defined. This is the grade 4.
You are appearing in all the 3 items.
Yes, ma'am. Item.
So how many items?
Disciplinary.
So there are total 9 matters.
Yes, ma'am.
You are appearing in all the 10 matters.
Yes.
What is the issue?
All the petitioners are the disabled persons. These petitioners are the disabled persons, my Lord, holding certificate of benchmark disability, my Lord.
They are disabled.
Yes, my Lord. Recommended by the selection committee, my Lord, allocating their. Now, subsequently, the government decided to hold the constitute a special medical board to reassess their disability, my Lord. Accordingly, they appeared, their disability was assessed, my Lord, but the communication were not special constituted board. Approached this honorable court, directed the government to furnish the report, granting liberty to challenge that decision of the government to hold the reassessment exercise, my Lord.
And furnish report
and the decision of the government to hold the reassessment exercise. In the meantime, my Lord, before getting the report, my Lord, the select list of the merit list, my Lord, it was expired on, my Lord, 8/9/2024, my Lord. 8/5/2024, my Lord. Through petition.
Your prayer is solely for extension.
Extension, that has been not, yes, item number 3.
Item number 3 in. This honorable court in the earlier.
Last order, Lordship Policy 9/5/2024.
Yes, I have it in front of me.
No, my Lord.
It says that it is solely for the extension of provisional list.
Yes.
Without any consequential relief.
Therefore, the court was of the view that without your main prayer challenge.
In the other matters, the main prayer is there.
Yes, madam.
It is there, Mr. Chutia?
Yes.
In respect of the other matters?
There matters, my Lord, the prayer is there.
So, file it, sir. In those matters also, notice is not issued?
No, only first time has come.
What I am saying, my Lord, notice may issue, my Lord, because earlier occasion, this matter was dealt with by the Justice Code number 5. And code number 5 says, without opening any my view, but that is the authority has a right to verify it. Accordingly, board constituted and that verified, and they found that they have less than 40%. That was not communicated earlier to the petitioner. Ultimately, they have filed a case, they have communicated to them.
In item number 13,
Lordship Kalisi,
report of the medical board is also under challenge.
item number 13.
Anyway, then Mr. Roy, let notice go. At this stage, it would be difficult to grant you interim. Let us have the response. It has been, these matters are pending also.
And my lord,
one second, Mr. Roy. But Mr. Chotia, considering the urgency in the matter, kindly have the instructions by next week.
And parties is there, health is there, board is there, and
you can have the instructions, and
if everybody appeared today, then it will be helpful. Otherwise, if somebody is not coming,
no, is all the respondents not before this court today?
For only 1 and 2. 3 for the justice, social justice, standing council is the RMS does, and 4 is principal, health and family welfare.
So where are the standing council, health? Everybody, standing councils are there for all the respondents.
Yes, health is there.
You see, otherwise this court will pass interim orders. The only reason this court is saying that giving you a short time is to see if something comes out, and thereafter consider the prayer of the interim.
Yes,
so in that situation, a short date can only be given.
Yes,
otherwise, there is no point for the litigants to come to the court.
The standing council had Balot Gogoi, no? He Gogoi.
Where is he?
He Gogoi Balot.
Give their name, you all inform.
I will inform.
Item number 16, my lord. I am appearing for respondent number 6, my lord. Director Soil Control.
We'll do it like this. Give all the item numbers.
Yes, ma'am.
Give all the item numbers.
Yes.
And then you write, heard Mr. S.K. Roy, Learned Counsel for the petitioner. Stop. Also heard Mr. T.C. Shutia, Additional Senior Government Advocate for the state respondents. Mr.
D. Upamanya.
D. Upamanya for health, Standing Council Health. And anybody else? Mr. C. Sharma for Social Justice, Standing Council Social Justice, and on behalf of RM Das. MS Esquire, Learned Standing Council Education, Elementary Education Department. So, but is all the respondents not same? They're all different?
Different departments.
So then, issue notice, returnable 1 week. Considering the urgency expressed in the matter by the petitioner for interim prayer, it is expected that the respondent shall file their necessary return within by the returnable date. Stop. The prayer for interim order shall be considered on the next date. List on after 1 week at a date. List on so and so date.
So short time,
27.
3.
All the matters. For all the matters, same order. Khali telokor naam clear.
Item 13, 16, and from.
Councils don't leave. Just in respect of the items, mention where your names has to come. Mr. Roy, you also oversee it.
Let me read, okay? For 38 application. Yes.
466, 420, 467.
Yes.
FIR is at page?
Internal page 17.
Land mafia.
Land mafia.
Allegation is made. Actually, here in
The
this case,
FIR appears to be a bit vague.
yes.
It has come to know that this fake deed is connected with the above mentioned accused and presently arrested so and so, who is presently in police custody. Anyway, short date you have the
31st of May. 31st of
call for CD list on 31/5/2024.
Item 52.
Supplementary, does it?
the item will pass off for the time being. The conductor custody is on leg.
All right, time being. 50? Are you getting? Agila goal already. Yes, Mr.
Standing
Majumdar?
here, I just heard the other case, item 15, that the non-family posting and the family accommodation. This is somewhat similar, my lord, to that matter. I'm also depending on one of the stay orders passed by this honorable court, and the which had curtailed the period to 3 years from the place of posting.
Is that same matter?
Same matter.
Retention, no coercive steps.
Yes. There is one aspect of the matter, my lord. Here he was allowed to retain the quarter up to 4th of May 2024. Extensions has not been given after that.
Sorry, Mr. Majumdar?
He was given an extension up to 4th of May 2024.
The petitioner?
Yes. Now we are challenging the same OM which is restricting and which is coming in
And
the way.
also for non-consideration of further extension. That similar order is here.
Yes, my lord, that the order where the stay was granted, I'm sorry, my lord, that order I have not annexed here. That order lordship should find, if lordship allows, my lord. Made a
Yes, yes,
petition as
yes.
petition. The third flag, lordship, would be the first order where the stay was granted. And the fourth flag is, my lord, the application to other repetitions. Same order.
Fourth flag is?
The fourth flag is where it was extended to all repetitions pending before this honorable court. The third flag, my lord, is where the first interim order was granted. Procedural. All over India, and on a request by the respondents, all matters have been transferred to this court, my lord.
That was the similar matter is item number
15, my lord.
15
Mr. Dihinga had appeared, I just heard it.
of the other court. Okay, item 15 court number 5 or order to side logo. 15.
Notice and no coercive action.
Respondent was same there, no?
My lord, here the respondent should be the. His respondent is ITBP, my respondent is BSF.
Heard Mr. R.M. Majumdar, Learned Counsel for the petitioner. Stop. Also heard MS
Bormon.
and
On
Bormon.
behalf of Mrs. A. Gayan.
On behalf of MS
A. Gayan.
A. Gayan, Learned Deputy
CGC Lordship.
CGAC. Standing Counsel CGAC. If it is the same order, I'll pass the same order then. Eketai order hobo. Here side logo. Ito ba check kori loba, ha?
Just for information, that I am R. Majumdar, my lord. The middle name is not there, my name.
R. Majumdar.
Item 6 for admission.
Yes. Yes, updated status.
My lord, our updated status is, my lord, though we have in the year 2014.
Though he has?
For sanction of fund, the department DC has returned to the concerned department, revenue and disaster management, but they have not released yet, madam.
Who is appearing for revenue? Yes. Please give me your instruction. But this information of yours is of 13th April. On 8/5/2024, this court directed you to get the updated status.
My lord, updated status is still awaited, my lord.
So therefore, you see, Mr. Counsel, you all are officers of the court. You have a duty. Now, if you had these instructions, you could have placed these instructions on the last date. You have said that the up-to-date instructions is required, and therefore, based on your submissions, this court passed that order. But what it looks like, your instruction is already over. You are saying that you have already given sanction. Now, financial sanction is yet to be received from the revenue and disaster management.
Yes,
so once you receive that, then you can go ahead. Correct. On the last occasion, if you would have submitted this, then on behalf of revenue, they could have had the latest instruction by now. But you see, this is a very old matter. As per these instructions, it appears that the district administration, Kokrajhar, has already submitted proposal addressed to the additional chief secretary government, so and so, for sanction of financial lesson. And now, this was done way back in 2013-14. Nothing has been done till now. This cannot go on. Let her obtain the instruction.
As the last.
Your name?
Yeah.
Mr. G. Mukulia, Learned Counsel for Learned Government Counsel.
Yes, madam.
For the state respondent submits letter dated 13/5/2024. Indicating that the office of the District Commissioner Kokrajhar has already submitted proposal to the additional Chief Secretary to the Government of Assam Revenue Disaster Management Department, Relief and Rehabilitation Branch, for sanction of financial assistance to the persons who were injured during the Ethnic Violence 2012, within bracket, comprising 57 numbers of grievous injured and 13 numbers of minor injured.
Simple injuries.
Simple injury. Grievous injuries are simple injury. Vide letter dated 3/7/2014. In terms of the government notification dated 24/1/2013, to accord sanction for financial assistance to the injured person. Stop. It appears that the district administration is yet to receive financial sanction order from the Revenue and Disaster Management Department. It is unfortunate that despite the communication dated 24/1/2013 of the additional deputy commissioner of the district administration, no sanction has been accorded by the Revenue and Disaster Management Relief and Rehabilitation Branch till date. Stop. Before considering the writ petition on its merit, comma, by way of a last chance, MS G. Hazarika, Learned Standing Counsel, Revenue, is provided time to furnish instructions as regards the status of the subject sanction. Stop. List this matter on 29/5/2024. Stop. Needless to clarify that the Revenue and Disaster Management Department shall take up the matter with utmost priority and furnish the instructions as sought for by the next date. A copy of the letter dated 13/5/2024 is kept on record and marked as X.
Item 7.
May it please, my lords?
Yes.
This is a writ petition filed by the APDCL, my lords, impugning an order
APDCL writ petition?
Yes, my lords. Impugning an order passed by the Ombudsman, by the Electricity Ombudsman, my lords. The impugned order is at page 56. If I may just place the facts, my lords.
You are challenging a notification of the Electricity Department?
No, my lords. We are challenging the respondent here, my lords, is a consumer of the APDCL. We had raised a supplementary bill. That bill was put to challenge before the Consumer Grievance Redressal Forum, my lord. That forum decided in favor of the APDCL, and against that order, the respondent had gone up in appeal before the Ombudsman. Now, the Ombudsman has given an order.
You are challenging the order of the Ombudsman?
Yes, my lords. Now, if I may just place the facts, my lords. Now, the respondent, my lords, herein is a consumer of the APDCL, my lords, and initially given a power connection of 67 kilowatt. I'm sorry, my lord, 16 kilowatt. Now that was enhanced to 25 kilowatt with effect from October 2006, my lords. Now an inspection was carried out in 2007 thereafter, my lords, which my lords will find at page 18.
Page?
18, my lords, of the writ petition.
Yes.
Now this was done subsequent to the load enhancement of 25 kilowatt, my lord.
Yes.
What is important here, my lords, is serial number 5 here, my lords.
Yes.
This refers to a term called MF. This is a multiplying factor, my lords.
Multiplied?
Multiplying factor.
Multiplying factor.
Now this was 1 when the connection stood at 16 kilowatt. Now moment it was enhanced, on the right side, my lords will see that it was enhanced to 10.
16 kilowatt. And then?
Moment it was enhanced to 25, it became 10.
10.
Now this is admitted, my lord. This was in fact even endorsed by the respondent. Whether or not the factor would be 1 or 10 is not disputed, my lords. Page 19 is the original, where it bears the signature of the representative of the respondent, my lords. Now inadvertently what had happened, my lords, the multiplying factor was enhanced. So thereafter the bills had to be in consonance with that multiplying factor. That was inadvertently missed out by the APDCL, my lords. There was a bona fide error on our part. So from 10/9/2007 to 31/1/2015, the multiplying factor of 10 wasn't applied. What we did was we inadvertently applied the multiplying factor of 1. So that was discovered during an inspection report of...
Come again, Mr. Chaudhary. You are B. Chaudhary, right?
Now, my lords, the multiplying factor is clear, my lord. This is clear. 10. We had to apply 10. Now, what had happened was inadvertently from the period thereafter, my lords, 10/9/2007 to 31st January 2015.
10/9/2007 to
31st January 2015. Instead of applying the multiplying factor of 10, we applied 1.
All right.
So, moment it was discovered, because we were accruing a loss
And this 10, this 25 was done in 2007.
Yes, my lord.
Therefore, you are saying 10 applies, and from 2007 onwards, you ought to have applied the multiplying factor 10.
10, my lord. There was an error on our part. We applied 1 instead, my lord.
Yes.
Now, moment we discovered this error, my lords,
Yes.
we furnished a supplementary bill to the respondent, my lords, which is at page 22.
Page
22, my lords.
22.
Yes, my lords. And now it starts at 21.
Yes.
See page 21, my lords. Enclosed, please find herewith a supplementary bill amounting to 11,58,497 for underbilling due to billing on wrongs MF from 10/9/2007 to 31/1/2015. This is to mention here that energy bills for the said period was served considering MF as 1.
All right, understood.
Now the page thereafter, my lord, page 22 is the bill. Now this bill was challenged by the respondent, my lord. He approached the CRF, which is the Consumer Grievance Redressal Forum.
Where is that order?
Yes, my lord. That order is at page Annexure 5. Sorry. Yes. Page 33.
Page 33. 33 is the
I'm sorry. No,
Ombudsman.
32. 30, my lord. Page 30.
Yes.
Now the CGRF decided the matter in favor of the APDCL.
1 second. This is page 30.
Page 30 is the order, my lord.
Page. This is the appellate.
This is of the Consumer Grievance Redressal Forum, my lord. The authority below the Ombudsman.
No, but it doesn't say so. This is at page 30, annexure 5.
Yes, my address of the grievance in CGRF, my lords.
Address in CGRF.
Yes, ma'am. Consumer Grievance Redressal Forum, my lord.
So it is called what? Consumer
Grievance Redressal Forum, my lord.
All right. This is the order dated
8th of August 2015, my lord.
18 August, yes.
Now, my lords, the judgment, the operative portion is at page 31. The CGRF holds that the action taken by the area manager so-and-so was as per the permitted procedure of the company as per the existing law in force. Thus, the area manager IRCA was not seen to be culpable
So
so-and-so.
this is in favor of you.
Yes, my lord. Then they go, they assail this very order before the ombudsman.
Ombudsman. That is at page 33.
Yes, my lord. 56 is the order of the page 56, my lord, the order of the ombudsman starts, my lord. Now, before, my lords, I take, my lords, page 56.
Page 56?
Yes, my lord. It's
What is the order date?
Order, my lords, is dated 7th of January 2016.
Yes.
My lords, before I take, my lords, to the order, my lords, may kindly have section 56 of the Electricity Act. This is relevant in this topic.
Not yet. Mr. Chaudhary, in a given case like this, before you issue the bill, are you not required to put the consumer on notice?
He was given the requirement. There is no statutory requirement.
There is
as
no
such.
statutory requirement.
He was given the supplementary bills and everything. He was given the statement of accounts and how the bill was completed.
All right.
That was done.
You see, because it was at your fault,
Yes, yes.
you have assessed by multiplying 1 instead of 10 for that particular period, right? For after you have realized your mistake, perhaps I don't know what are there in your, but the consumer perhaps was required to be put up on notice that this has happened, and therefore now we propose to take this action. Something like that ought to have been done, isn't it?
Yes, my lords. Perhaps, my lords.
Anyway.
Yes.
Section
56, my lords. Subsection 2 here is important, my lords. Now, 56 deals with disconnection of supply in case of default of payment. Subsection 1 isn't relevant, my lords. Subsection 2.
So you disconnected?
No, my lord, we have not. We have not.
Yes.
Notwithstanding anything contained in any other law for the time being in force, no sum due for it from any consumer under this section shall be recoverable after the period of 2 years from the date when such sum became first due, unless such sum has been shown continuously as recoverable as areas of charges for electricity supply, and the licensee shall not cut the supply of the electricity. Now, there is a limitation here, my lords, of 2 years.
2 years.
Now, what the Ombudsman essentially held is that there is a limitation of 2 years. So the period that you say the supplementary bill is for is from 2007 to 2015, and the bill is from on 29th April 2015.
Bill is
9th of April 2015.
29th April
2015, my lord.
So that is.
So he basically.
But this is for the period of 2007 to 2015.
15. So he goes on to hold that the Ombudsman, my lords, which is basically now that issue has been put to rest, my lords. Supreme Court has come out and clarified the issue. Now, what the contention of the respondent was, page 58 of the writ petition, my lord.
Just 1 second. It says under this section shall be recoverable after the period of 2 years from the date when such sum becomes first due.
First due.
Unless such sum has been shown continuously as recoverable as area of charges.
Yes. So what is important here is first due, my lords. So the contention of the respondent before the Ombudsman, my lords, that
is the finding?
Yes. If I may just show the contention, my lord, page 58, third paragraph from the bottom, my lord.
Why Mr. Pathak has taken backstage in this matter? Anyway.
The third paragraph from the bottom, my lords, page 58. The appeal petitioner further relies upon section 56 of the Electricity Act and said that the bill dated so and so is illegal and in violation of the provisions contained in subsection section 56. As I said, section demonstrates a period of limitation of 2 years. Now the finding in that 62. Sorry, my lords. Page 62.
Page
62, my lords. The penultimate paragraph, my lords. The above discussion and observation.
1 second, Mr. Chaudhary.
My lords.
Yes.
Yes. The second last paragraph, my lords. The above discussion and observation, including examination of records submitted by the appellant and respondent APDCL, it is now seen that the first due date of the present case shall be 7/5/2013. So he takes the bill of 29th April 2015 as a reference point, backtracks 2 years, my lords, saying that it can only claim.
No, he takes which date as a referral point?
The bill date, my lords.
Bill
the date
date.
of the bill, which is 29th.
Bill is 29/4/15.
Yes, my lords. So applied. Yes. He goes back 2 years and says you can only claim for this period. You cannot go back to 2007 and claim for a period of 2007 to 15.
The bill date for the monthly bill period from 2/4/13 to 2/5/13.
Yes.
So this, on the face of it, doesn't look to be wrong.
My lords, it's
because Mr. Chaudhary,
yes, my lord.
Your bill dated 29/4/15 is for a period from 10/9/07 to 31/15, correct? And your contention is that for this period, the multiplying factor should have been 10. However, inadvertently, it was 1.
Yes.
Very right. Now, for post, the cutoff date will let us take it as 7/5/13.
Yes, my lord.
Correct. Now, pre-7/5/13, whenever it was recoverable, it will have to start from there 2 years. If you count that, then for that free period, it is time barred. Post 7/5/13,
yes,
it is within time. This is what it says.
There are Supreme Court judgments, my lords.
I will go to the judgments
Yes,
later, Mr.
yes.
Counsel.
Yes, if applying it in that manner, yes, my lords.
And going by
Yes.
the provision is very clear. Is there any ambiguity in the provision?
There is no, my lord. But it has been interpreted in a different
So
manner by the
the
Supreme
facts has to be understood in the context.
Yes.
The law has to be understood in the context of the facts, correct?
Yes.
In your admitted position is pre-7, the cutoff date will be 7/5/13. Let us take it that, because your bill was raised on 29/4/15, right?
Yes, madam.
So any amount which is pre-7/5/13 will be time barred. Post-7/5/13, of course, you can recover. There is no difficulty. Yes. This is in terms of subsection 2 of section 56. Now show me what is the Supreme Court judgment.
Relying on, my lord, says
Please give a copy to the other side.
I do not. I'll just share a copy. 2021 20 SCC 200.
Which page?
My lord, page 7, para 10, 11, 12. My lords.
Para?
10, 11, and 12.
What is the meaning of first due?
Yes, first due, my lord. And also when there was an error, inadvertent error, my lord, they've also dealt with that issue. Now, para 10, my lord, they're referring to a case, earlier case of Ajmer Vidyut Vitran Nigam Limited versus Rahmatullah Khan, 2024 SCC 650. In Rahmatullah Khan, 3 issues arose for the consideration of this court. They were: 1. What is the meaning to be ascribed to the term first due in section 56(2) of the Act? 2. In case of a wrong billing tariff having been applied on account of a mistake, when would the amount become first due, my lords? I'm not dealing with issue number 3. Para 11 thereafter, my lords. On the first 2 issues, this court held that though the liability to pay arises on the consumption of electricity, the obligation to pay would arise only when the bill is raised by the licensee, and that therefore electricity charges would become first due only after the bill is issued, even though the liability would have arisen on consumption. Now this is what has been held. Now para 12 thereafter, my lords. This is again in reference to that very earlier judgment. Despite holding that the electricity charges would become first due only after the bill is issued to the consumer, and despite holding that section 56(2) does not preclude the licensee from raising an additional or supplementary demand after the expiry of the limitation period prescribed therein, in the case of a mistake or a bona fide error, this court came to the conclusion that what is barred is only the disconnection of supply of electricity. So the claim is not barred. Only we are.
When there is a bona fide error.
Yes, my lord. This has been settled by the Honorable Supreme Court. Now, this is my case in hand.
This decision is Ajmer Vidyut Vitran Nigam.
Yes, my lord. 2024 SCC.
You are having that?
I do not have that, my lord. I can place it, my lord.
That clarifies further.
Sorry?
That clarifies.
Yes, let
that
us.
decision is. This is relying on it. This decision.
That is why this court wants to have a look at it.
In fact, it's very.
Which para?
Para 5.1. Analysis will Lordship will find from para 6.
This para 5.1 is quoted here, isn't it?
5.1 is the amicus curiae who gave his opinion, so that can.
All right. The analysis starts from 6.
The analysis starts from 6. Mail. Also, before going there, there is also one supply code which is applicable to our.
Let him first finish.
Before this judgment, I shall be playing.
They have not filed a affidavit.
I have not understood that part. You complete your arguments.
Yes,
Wait.
This is the.
Do you have a copy of this? 2020?
I'm just looking at it, my lord.
If you have it?
On my, yes, my lord, on my.
Can you read from para 6?
Of course I can. Para 6, my lords, yes. Findings and analysis, my lords. The Electricity Act is a consumer-friendly statute. The statement of objects and reasons to the Act notes that over a period of time, the performance of state electricity boards had deteriorated on account of various factors, and the need was felt to frame a self-contained comprehensive legislation which led to the enactment of the 2003 Act. The electricity has been held to be goods by a constitution bench in state of so-and-so. Under the State of Goods Act, a purchaser of goods is liable to pay for it at the time of purchase or consumption. The quantum and time of payment may be ascertained post facto either by way of an agreement or the relevant statute. In the case of electricity, the charges are ascertained and recovered as per the tariff notified by the State Electricity Board or under an electricity supply agreement between the parties read with tariff under Section 62 1D and Electricity Supply Code framed under Section 50. The present civil appeal pertains to the interpretation of Section 56 of the Act. 56 is quoted, my lords. Section 56 provides for disconnection of supply in case of default in payment of electricity charges. Subsection 1 of 56 provides that where any person neglects to pay any charge for electricity or any sum other than the charge for electricity due from him to a licensee or generating company, the licensee shall, after giving 15 days written notice, may disconnect supply of electricity until such charges or other sums due, including expenses incurred, are paid. However, the disconnection cannot continue after the amounts are paid. The obligation of a consumer to pay electricity charges arises after a bill is issued by the licensing company. The bill sets out the time within which the charges are to be paid. If the consumer fails to pay the charges within the stipulated period, they get carried forward to the next bill as arrears. The provision of subsection 1 of Section 56(1) carves out an exception by providing that the disconnection will not be effective if the consumer either deposits the amount under protest or deposits the average charges paid during the preceding 6 months. Subsection 2 of Section 56 by a non-obstant clause provides that notwithstanding anything contained in any other law for the time being enforced, no sum due from any consumer shall be recoverable under Section 56 after the expiry of 2 years from the date sum became first due, unless such sum was shown continuously recoverable as arrears or charges for the electricity supplied, nor would the licensee company disconnect the electricity supply of the consumer. The effect of the non-obstant clause was explained by this court in...
Come to 6.9.
Yes, madam. The liability to pay arises on the consumption of electricity. The obligation to pay would arise when the bill is issued by the licensing company, quantifying the charges to be paid. Electricity charges would become first due only after the bill is issued to the consumer, even though the liability to pay may arise on the consumption of
the electricity charges would become first due only after the bill is issued.
Yes.
So not
at the time of consumption.
Not at the time of consumption. Now here
bill is of 29th April 2015.
But in that bill, this amount was not there. The multiplying factor 10, whatever that enhanced it would be, that was not part of the first bill.
Of 29th April, my lord?
Of the first, yes.
It is, my lord. It is.
No, not 29 April.
2007, yes, it was.
Yes, it was not there. So can it be then said that it has become first due?
Moment it was, because the judgment that I first relied on, my lord, it also takes into account bona fide errors or inadvertencies.
I understand. In fact, this query that this court is putting is in your favor.
Yes, my lord.
What I am asking is, because first due has been interpreted by the apex court in this decision as to be from
the date of
issuance of the bill. Right?
Yes.
Now suppose a bill is issued for 500 rupees and you have not paid that 500 rupees. After expiry of 2 years, you cannot take recovery of that 500. But suppose it should have been 600. So 100 rupees was not mentioned in the bill. Now later on, you mention 100 rupees by a bill dated 29/4/15. So that 100 rupees will be first due from 29/4/15.
Yes, my lord. Yes.
Am I clear in this?
Yes.
In that case, this limitation will not come because they have already consumed.
Yes.
But it was not part of the 2007 bill.
Yes, my lord.
Therefore, it doesn't come. I don't know if I'm making sense, but this is how I have understood.
Yes. Rightly, my lord. Yes.
Is it right?
My lord.
Okay. Then
Now the Ombudsman, my lords, then goes on to hold that he, like I showed, my lords, at page 62. So he took, the Ombudsman took 29th April 2015 as a reference point.
So according to you, this is erroneous.
This is erroneous. I with the challenge.
All right.
Filed an affidavit in opposition. They have not even contributed.
Not required.
But maybe all the records and everything.
Facts are all admitted. Now the issue is solely interpretation.
56.2. There is no other.
Absolutely.
There is no dispute to the facts that bill everything is.
So you may restrict your reply to that to the interpretation part. Correct?
I'll restrict to only that.
Yes, please. Yeah. Yes.
Lordship, the bill, the first bill was of 2007. According to them, it should have been the multiplying factor of 10. That came to their notice. What this judgment is saying is that a limitation period, the limitation period runs, first due would be, as Lordship, in my opinion, would be what the Ombudsman has opined. And the judgment talks about, it does not preclude the licensing authority from approaching other authorities. This limitation act, this 2 years limitation will not bar. They can file a money suit for that. There they have to show their bona fide mistake, because here in the supply code, there is a requirement under the supply code wherein they ought to have checked the meter every year. They did not do that. They have to do when the money suit will come. Now what was under challenge in the first?
Is there a bar under the Electricity Act for raising a bill in case of inadvertent errors?
No, this 56.2.
That is the time period.
So there is no bar.
Mr. Das, 56.2 doesn't say in case of any error or anything, right? It is simply a general provision that on the expiry of 2 years from the amount being first due, there shall be no recovery.
The legislature
is banned.
The legislature enacted 56.2 to give them a handle to the licensing authority, so that if they disconnect the line, at least they will pay up the money. That was the handle.
Correct.
No other objective of 56.2.
Now this has been interpreted by the Apex Code.
Right?
Now in that case, first due is not from the date of consumption, but from the date of issuance of the bill.
Yes, for the issuance of the bill. Now issuance of the bill would be, the next part, areas, if not shown as areas. So if they had shown as areas, suppose 2007 area payment, then 2 years limitation would not come, in my respectful
because that is continuing.
In my respect, there's a continuous.
There is a case where they are not even concerned about, because at that time they didn't know that this amount is due.
Because they had not checked.
Because of some mistake.
The word is bona fide mistake. No,
yes.
Bona fide mistake.
So inadvertently this was left out because it was not in their knowledge.
So the bill came after.
Obviously they knew that 10%, it has to, the multiplying factor at 10 should have been adopted.
Yes.
But due to an inadvertent, it was not done so at that time, and it did not came to their notice. No. Later on it came to their notice, and they issued a bill.
Yes.
So now the question is, the first due will be from the bill dated 29/4/15 or from 2007 at the time?
The 15, in my respectful submission, 2 years back. As calculated by the Ombudsman. Right. That is my, because the first due interpretation as per the Apex Code is that only, in my respectful submission.
Yes. From which part of the Apex Code decision in Rahmat in Ajmer Vidyut?
Rahmatullah Khan.
Yeah, yes.
9.1, if Lordship reads.
Yes.
Section 56.2 did not preclude the licensing company from raising an additional or supplementary bill after the expiry of limitation period under 56.2. Now, why is this?
So, see, you have to read it together, the entire 9.1. Now, in this
case of-
case, if I have understood correctly, they have distinguished the demand. They have said one would relate to recovery, one is to disconnection.
Disconnection.
Now, according to this decision, it says one should not take recourse to the cohesive measure of disconnection.
Disconnection. For the 56.6 is only for the purpose of disconnection. The whole challenge started off with the bill. The bill was given. If you don't
But here,
pay the-
this is not a case of disconnection. They are not.
It is a case of disconnection ultimately, because the bill was given. If I don't pay that bill, my disconnection, they would have disconnected my electricity.
There is a start. We
Yes.
cannot possibly, Manoj. We cannot.
But the ombudsman decision doesn't talk about discussion.
Supreme Court judgment is clear, Manoj. We can issue a supplementary bill, but we
Correct,
cannot take
but
recourse
not disconnection.
to disconnection.
Because for disconnection, there are other remedies available.
Yes.
This is what,
For
if I have
disconnection, only
understood.
56 is available in my respectful submission. If the bill is taken,
See para 7.5 also. In
Your
fact,
Lordship,
para 7 will make it clear. If you see para 6, and then come to para 7.
the next issue is whether limitation of 2 years provided by
Would be
56
applicable to an additional or supplementary demand. Now, prior to this, what was the issue? The issue was that what is first due?
First due.
And it says the liability to pay arises on the consumption of electricity. The obligation to pay would arise when the bill is issued by the licensee company quantifying the charges to be paid. Electricity charges would become first due only after the bill is issued to the consumer.
Yes.
Even though the liability to pay may arise on consumption of electricity. Now, this court is of the opinion that in the present case, the liability from 10/9/07 to that cutoff date is 2013. What was that date, Mr. Chaudhary? That cutoff date?
31/5/2015.
No. 2013 date. There is a 2013 date.
Yes, 7/5/2013.
7/5/2013.
Yes.
Now, this 7 till 7/5/13, from 10/9/7 to 7/5/13, would not become first due at the end on the date of 2013 or 2007 when those bills have been raised. But on 29/4/15, because that part of the consumption was first issued in the bill of 29/4/15, not prior to that. Right, Mr. Chaudhary?
The MF factor, that part of the
That
consumption.
part.
That MF factor part,
The enhanced part.
The enhanced part is, now there is, in my respectful
Because
submission,
admittedly that part was first issued, first raised in the bill of 29/4/15, not prior to that. Therefore, in that view, this court is of the opinion that the 2 years limitation will start from 29/4/15.
Lordship,
So
here-
within that period,
Here the consumption has not changed. The number of units is the same. It is the multiplying factor which has changed.
correct.
If there is the consumption which has been talked about, that means it might have happened that there was underbilling. If there was underbilling and that part was not taken into consideration, that consumption factor might have come. Consumption, the word consumption is important in my respectful submission. Because here it is not a question that I have consumed more, paid less, then they came to know that this amount was consumed more, but this bill was not raised. Here is a question of multiplying factor. This multiplying factor is not at my hand, it is at the hand of the billing person. It is not even to there is nothing to do with the meter. The meter would have been the same. The reading will be the same. It is only the multiplying factor. It is into 1 or into 10. So here there is not a question of consumption.
All right. Now, what is your reply to the subsequent decision which has been relied by the other side in Prem Kotek?
Saying reiterating the same thing in my respect. I have read the judgment.
Please read para 11 and 12 again. What do you have to say to this?
On the first two issues, this court had held that though the liability to pay arises on the consumption of electricity.
Please read.
The obligation to pay would arise only when the bill is raised by the licensee, and that therefore electricity charges would first become due only after the bill is issued, even though the liability would have arisen on consumption. On the third issue, this court held that the period of limitation 2 years would commence from the date when the electricity charges became first due. Now, the first aspect of the judgment is again about the consumption. Again, the first due would be again relatable to the consumption part only. This court also held that 56(2) does not preclude the licensee from raising an additional and supplementary. This has been read from raising an additional or supplementary demand after expiry of the period of limitation in the case of a mistake or bona fide error. To come to such a conclusion, this court also referred to Section 17(1)(c) of the Limitation Act and the decision of this court in Mahavir Kishore versus State of MP.
What does this say? This court also held, does not preclude. Okay, yes.
Despite holding the electricity charges would have become first due only after the bill is issued to the consumer, para 6.9 of the SSC report of Rahmatullah, and despite holding 56(2) does not preclude the license from raising an additional or supplementary demand after the expiry of the period of limitation prescribed therein in the case of a mistake or bona fide error, para 9.1 of the SSC report of Rahmatullah, this court came to the conclusion that what is barred under 56(2) is only the disconnection of supply of electricity. This is my submission.
All right.
The first, if I complete, in other words, it was held by this court in the penultimate paragraph that the licensee may take recourse to any remedy available in law for recovery of the additional demand, but is barred from taking recourse to disconnection of supply under Section 56(2). This is where, now, when this bill is given, if this bill is not paid, today, the first instant would be that when this bill was given, I approached the authorities. The first authority did not entertain my contention, so I approached the appellate authority. The appellate authority said that this bill actually ought to have been within 2 years, which in my respectful submission is correct. Now what they can do right now is that regarding the other part, they can go for other remedies available under law, whatever be this is what they are saying. 56(2) is only relatable to disconnection of a connection, electricity connection. So now if this is restored, now the period has to be under this first due part. In my respectful submission is again 2 years only limitation. Here it's not a case of consumption is important here. Multiplying factor is here where there is under consumption, that means you consume the here as a businessman.
All right. Anything else? I'm keeping the matter on Monday for orders. Written part kori list on Monday date to date. 5 to start lagi ba? Ito citation to lagi ba? Print anile khali tate paragraph to read dibo lage. Engon naam to samma ke rakhiba. What is doing the delay? I reckon maybe like it. All right.
Deeply.
Yes.
This matter pertains to regulation of a work charge employee serving in Public Works Department.
For what?
A matter pertains to regulation of a service of the employee.
Regularization.
Serving in Public Works Department, and he is in the verge of retirement lordship, and now it has come to notice of the petitioner that the juniors who are junior to him in the service have been regularized by...
So Nayak?
Notice?
Heard. Mr.
Yes, sir. Lordship, the name of my senior SP Chaudhary may be reflected.
Your senior is not before this court. You are there.
I'm there.
Heard Mr. So-and-so, learned counsel for the petitioner, stop. Also heard Mr. P. Nayak, learned
I'm appearing for respondent number 1 to
Learned Counsel for respondent number
1 to 5, Lord.
1 to 5.
Both finance and PW as well.
So I will say for 1 to 5.
Yes, Lord.
For BTC,
BTC S. Prabha was appearing.
Mr. So-and-so for BTC. Standing Counsel BTC for respondent number
6789.
89. What about Principal Accountant General?
No one is appearing.
Mr. Gogoi? Government can appear?
No, they have their own standing. Same AD is there, Lord.
Through this writ petition, the petitioner is seeking direction for regularization of the service of the petitioner from the date of his initial entry in service, considering the continuous service of the petitioner for more than 32 years. Stop. Issue notice, returnable 4 weeks. Mr. P. Nayak, Learned Counsel for the petitioner, Learned Counsel for the respondent. You are appearing here as Standing Counsel.
Yes,
Learned Standing Counsel, PWD, accepts notice on behalf of respondent 1, 2, 3, 4, and 5.
One more is there, Lord. Respondent number 9, Lord.
And 9. 8 also, I think.
8, Lord, BTC.
Achha. And 9, huh? Then Mr. So-and-so
S. Prabha.
is not here.
We are sitting here, Lord.
Mr. So-and-so, Learned Counsel, Learned Standing Counsel, BTC, accepts notice on behalf of
6,
7, and 8. Stop. Mr. So-and-so accepts notice on behalf of 10. SK Medhi.
SK Medhi.
Shall I give his name?
I will inform him, Lord.
SK Medhi. For 10. Extra copies within the course of the day. List after 4 weeks and a date to be fixed by the registry. Please, Mr. Nayak, please inform the concerned councils.
May I please the Lordship? Lordship, in this case, I'm tendering my apology. On last occasion, I could not be able to remain present.
So, Mr. Sorry, I cannot hear you.
My Lord, on last occasion, I could not remain present before this
occasion,
my Lord.
So you are appearing for the petitioner?
Yes, my Lord.
Your name? Mr. S.C. Das has Mr. S.C. Das appeared on behalf of the petitioner today when the matter is called. Stop. It may be pointed out in view of 2 consecutive failure of representation on behalf of the petitioner on the last 2 occasions, this court directed listing of this matter today with the remark for dismissal. Stop. In view of the representation on behalf of the petitioner through his counsel, Mr. S.C. Das, since today Vilikodia has represented so and so, list this. When do you want it for admission?
My Lord, I have no some time to.
Last Mr. So-and-so Das submits that since he is not being able to contact the petitioner, some accommodation in the matter may be granted. Stop. Prayer is not opposed. List this matter. 3/6/2024. But ensure that you appear on the next occasion.
My Lord, I am appearing on behalf of the petitioner, my Lord. Submit, my Lord, I want to retire from this case, my Lord. I have already communicated to my clients, my Lord, by registered post. And here, my Lord, the SKJN lawyer is expired, my Lord. And name is reflected BKJN and S. Talukdar and
But your name appears in the, you have signed the Wakalatnama. How can you retire from the brief like that?
My Lord,
you have informed the clients about your difficulty in appearing.
Yes, ma'am.
They have not made alternative arrangements.
My clients are willing to engage some other counsel, my Lord.
When did you inform them?
My Lord, recently.
Recently?
In the last, when the case was listed.
Mr. Your name?
BK Jain.
Mr. BK Jain, learned counsel for the petitioner, submits that due to personal difficulty he shall not be able to appear in this matter, and accordingly he has already informed the petitioner recently. Stop. In view of the above, list this matter after 2 weeks. Registry shall reflect the name of SC transport in the cause list. Needless to clarify that since the matter pertains to the year 2017, Mr. BK Jain is requested to inform the petitioner by way of registered post AD as regards the right of the petitioner to be represented through another set of counsels on the next date fixed. Please inform. And yes.
My Lord, I have already informed.
The next date, you see, there is no alternative arrangement done, correct? So on the next date, if there is a counsel duly engaged, this court shall relieve you from this matter.
Yes, ma'am.
All right.
This matter will need some time. This matter will need to be heard at some length.
This matter will
need to be heard at some length.
Admit it.
Can it be taken up on 28th?
Well, admit and post it for hearing.
Very good.
It will be. I'll give you a date shortly.
The difficulty is that the petitioner has neither got the possession of the land in question, and his money for the last 8 years is with the bank.
Mr. Ganguly, this court is fixing your matter for hearing. Is there any difficulty?
No, on any date.
Admit. Heard so and so. Since this matter shall require a full-fledged hearing, let the petition be admitted for hearing. List on such and such date for hearing.
Can it be on the week after that?
Did ya?
Please, Your Lordship. Here the petitioners, they are the owners and possessors of the Patra land, measuring 17 biga, 2 katha, 7 lectures. Dag number 13 of PV Patra number 24.
No affidavits, nothing, no returns.
Here, my lord.
Yes. Revenue.
Subject to Lordship. It's transferred subject to Lordship BTC.
BTC?
Yes, Your Lordship.
Where are they?
Lordship, only I'm representing only respondent number 1. Rest.
No, but is revenue going to file an affidavit?
Lordship, actually it is a transferred subject, so instruction will be
From BTC?
Yes.
Where is BTC? Wait for a while. Yes, Mr. Saika.
By the order dated 2/5/2024, there is a request made by this honorable court for my appearance. The matter relates to some records which are misplaced or not found. apply in the Durga Sarovar Revenue Village.
Which order are you referring to, Mr. Saikia?
2/5/2024, 2nd of May. The third paragraph.
So, you were requested to
Yes.
assist this court.
Yes, so I'm seeking some more time, let's say at least 2 weeks more time.
Just
because they are-
only thing is that in the morning I'm told, yes. No, Mr. Saikia wants some time accommodation in the matter, as this court had requested his assistance. So this court will grant some time. All right. So you inform, because there is a request for VC on your behalf.
Yes, madam.
Okay. Itu ki dilla? How much time, Mr.
About 2 weeks time.
2 weeks time. As prayed for by Mr. D. Saikia, learned Advocate General, assisted by MSP Mohanta, R. Mohanta, list this matter.
On 2nd, just 1 second. 3rd of June.
On
3rd of June.
Such date?
Then in that case, Lordship, 18th of June.
18 June kore diba, report kore diba, which is not opposed from the petitioner. All right.
Deeply obliged.
Take this back, Ms. Mohanta. Yes? I'm sorry, I could not hear you. Yes, Mr. Bora?
Yes, my lord. Last occasion by order dated 23/2024, as well as 18/3/2024, the Honorable Court directed the respondent
Instructions.
to file an instruction, madam.
Yes.
Lordship, I have obtained an instruction whereby the table has been given in this regarding the quantum of the compensation of the houses which got demolished during the eviction process at Hikaku, Your Lordship. For the RCC house, it is being estimated as 10 lakhs. And for Assam type, it is 5 lakhs. And how many number?
Mr. Bora, perhaps these instructions would require to be placed by an affidavit. Otherwise, how would you...
Yes. They can file an affidavit, my lord.
Lordship,
Or that
this
may
is-
be...
This is the minutes of the meeting, Your Lordship. It is being signed by the...
So you file an
under the
affidavit.
CM.
You have not filed any affidavit in the matter till date.
Yes, yes.
So you place the instructions that you have received by way of an affidavit. How much time?
Their communication may be recorded, my lord. May be
No, Your
recorded.
Lordship, just...
It's all right. How
obtain
much
the-
time do you need?
2 weeks, Your Lordship.
MSN Borderler, right?
Yes, Your Lordship.
Learned Standing Counsel Revenue.
Yes, Your Lordship.
Submits that she has received the instructions in the matter, and accordingly seeks 2 weeks time to place the same by way of an affidavit. Stop.
Lordship, but this instruction has been obtained from the Department of Housing and Urban Affairs. So, I'll file it, Your Lordship. It's not from the Revenue Department.
No, but this is what the instructions that have been sent to you. Correct.
Yes, from
So
different department.
you find whatever it is then.
Yes. Okay, I'll file it, Your Lordship.
In the
Was already, my lord, given by Deputy Commissioner.
Lord.
My-
No returns have been yet made in this matter, correct? Now, for this court to proceed further, the returns has to be also there. So whatever is your stand, including the other government advocates, whoever is appearing, respondents, you file your respective returns so that the matter can proceed, and you include whatever that update is. Correct, Mr. Bora?
My lord.
Otherwise, it will keep unnecessarily every time the matter will be getting dragged. Should I also record your presence, Mr. Hendick? Mr. So-and-so also seeks time for filing returns. Prayer not opposed. List after 3 weeks on a date to be fixed by the registry.
It can be done 24, my lord.
3 weeks of piece of date.
God bless you.
Mr. Gogoi, you're not allowing them to cut trees.
This is the second round, my lord.
Yes.
Sure, my lord, I had got all the records.
We'll consider and pass orders in 1 week, my lords. Issue is probably of non-consideration of application. We'll consider every facet and we'll pass orders.
So what is to be done here?
Dispose it off, my lord. With the direction in 1 week, we'll pass orders.
All right.
It's up to them, my lord. It's a hill area and full of trees. If they have to cut it on peril, they are welcome.
Circle officer already report. From the reserve forest area, adjacent to the reserve forest.
Yes, Mr. Gogoi.
It is adjacent to the reserve forest 120 meters away also. And hilly area, it's not a plain area also.
No, this court is in view of the endorsements made by Mr. Gogoi. We are not entering into the merit.
Yes.
Where is his application? He has filed an application, Mr. Gogoi.
He seems to have filed an application. There is no application.
Application is not annexed, my lord, but
Then what will I ask to...
He is asking, my lord, on merits to accept the report.
How can you accept, how can this court allow that?
in all reports they have said on as per applications of their request. I have shown this.
Mr. Counsel, what is your case?
Yes, sir. We have applied for felling down of trees. We are owner of Miadi Battalion. We applied for
Where is the representation?
Representation. Actually, we have not received from the.
How you have straight away approached this court without even annexing the representation? You are seeking mandamus. Where is the representation? Where is your demand?
On the basis of our application.
Where is your application?
Application is not annexed yet.
Then your petition is incomplete. You are seeking for a prayer for mandamus. The basic rule for mandamus: demand and refusal. Where is the demand?
Actually,
Mr. Counsel, please answer to the query which has been posed to you. Where is the demand? Is that not the basic rule for a mandamus?
my lord, but in a, with reference.
This court will keep on. You see, you cannot make this court a medium for.
Application is not in our hand. Actually, we have filed the application, but we did not receive that. To the forest division.
Which paragraph you have said you have filed an application, filed a representation? Which paragraph? Please don't point paragraph 27. That's a very general paragraph where you say demanded justice but the same has been denied.
No. Application no.
Is it there? That averment?
Page para 24.
My lord, para 7, page 7. The petitioner begs to state that
Para?
Para 7. The petitioner begs to state that after receiving the planning permit, the petitioner applied for felling of trees, earth cutting and rest.
Mr. Counsel, please understand the query. What is your grievance? Your grievance is that this application has not been met, correct? This is the application for felling trees. Correct?
Correct.
So this is what you are aggrieved, but have you filed a representation?
No, my lord.
Then he has not filed representation. Straight away he has come. Yes, what is to be done?
Application record
Mr. Gogoi, before that there has to be an averment.
Yes,
That averment is not there.
24.
Therefore,
Whisper.
no, that is not 24.
24. It's unsubstantiated. Page 14, the concluding paragraph. Not allowed.
No, paper 24. They are not saying
The unsubstantiated list.
No, Mr. Gogoi, this court appreciates your help in order to see if something can be done, but that paragraph is lacking in the body of the petition. How can you assume?
দৰখাস্তখন আমাৰ লগত নাই কিন্তু এজ পাৰ আৱাৰ এপ্লিকেশ্যন এনেক্স হেৰিটো এই নাম্বাৰ টাইটেল এব জইণ্ট ভেৰিফিকেশ্যন was conducted for cancellation of partner transfer in respect of the land of Sri
Transfer here to joint verification. There is nothing, Malad. Even the annexures are silent.
Yes, yes.
People are mathi call to the hostan to 30 ইয়াত গছৰ কথাই নাই মাটি কাটা কথা আছে অকল
Yes.
Thing, my lord. Even the annexures only doesn't speak of any trees. Something is indicating there's a art cutting and my lord cancellation of some pata.
But on the basis of our application, verification was done. Annexer, my lord, Annexer 7, page number 31 and Annexer 12. On the basis of our application, joint verification was done. For instance,
so your first prayer is that a mandamus to accept the joint verification report. Can that be granted?
Cease of joint one joint.
In respect to Ashkari, my lord, may kindly peruse page 40.
Page
40.
40.
40, my lord, may kindly reference part. 40.
Earth cutting.
This is in respect to earth cutting.
And here that application is for felling trees. That is which paragraph, which annexure?
He's not there.
I think
no whisper, my
lord. Of tree, nothing is there. Only his prayer is there.
Mr. Counsel, your petition appears to be a frivolous petition. The joint verification report that you are relying, which you want a mandamus, is in respect of art cutting.
Cutting actually. After joint verification, annexure.
Yeah, the report, it says subject.
Page number 34, 37.
No, but what about 40?
Kindly page 34.
30?
Page 34. Report of joint verification of filling up area of Patala.
No, I saw trees. It is not very clear. You all file your affidavit. That is up to him. I am not going to give that leeway here because there is no, one cannot straight away come to the court. You take up all those grounds. How much time?
I'll produce the records, my lord.
You see, you have already on the last occasion taken time to file affidavit in opposition.
Yes, my lord. But
you file your affidavit. Why is it so difficult for us to file affidavit?
No, my lord, this is the second one. What will happen if?
No, you see, Mr. Gogoi, why this court insists on filing affidavit? Because once you file affidavit, everything is on record. The petitioner gets a chance to rebut. That is the right of the petitioner, correct? If you give us record, how will the petitioner know what is there in the record? How will the petitioner rebut? Do you understand?
I understand.
These are the basic rights of a petitioner, isn't it? So that and suppose after going through the record, this court comes to a finding that no, there is something, and therefore the same has to be filed by way of an affidavit. Another date in the meantime gets lost.
I'll file affidavit.
That is why this court insists that you file affidavits.
But these cases are peculiar circumstances. My lord, this is the second round.
Very well, take on those grounds.
First round, my lord, I had produced the record, court had perused it, and they had withdrawn that case.
Very well, you indicate that then. Mr. D. Gogoi, Learned Standing Counsel for the Forest Department, and who else wants to file anything?
Lordship, I also receive instruction.
And Mr. K. Gogoi, Learned Additional Senior Government Advocate for State Respondent, seeks 3 weeks time to file affidavit in opposition in the matter. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry. Yes, Mr. Chaudhary.
Lordship, as per the informant telephone instruction, Lordship, the land does fall under the reserve forest. I have to get the written communication.
You have to?
I have to get the written communication. It's just telephonic instruction.
Let him file his affidavit then. How much time?
2 weeks, Lordship.
Mr. D. Chaudhary, Learned Standing Counsel.
BTC.
BTC. Anybody else wants to file anything? Seeks 3 weeks time to file necessary return in the matter. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
27.
But in this case, my lord, government allotted land has become my lord khas land, my lord.
Has become?
Khas land, my lord. Yeah, my lord, what is happened, Annex 2 such.
Even in this matter, affidavits not filed?
Not filed, but a similar order has been already passed.
Mr. Handick, have you gone through?
And given me the copy also, my lord.
Is this case covered?
Lordship.
Covered?
Followed by this order, what has been annexed, my lord. This order passed, my lord, in another court.
Your land is also covered by the list appended?
Yes, ma'am.
So this court can dispose of this writ petition in terms of this order by granting liberty to the petitioner to approach the concerned R3, correct? Heard Mr. H. Das, Learned Counsel for the petitioner. Also heard Mr. J. Hendick, Learned Government Advocate for State Respondent. MS N. Borderloy, Learned Standing Counsel, Revenue. And who is there? Anybody else?
No, Lordship. Others are I appeal. 3 to 7.
It is submitted at the bar that this case is squarely covered by the decision of this court in the case of Shri Shashadhar Shil versus State of Assam in WPC 1374 of 2024. Stop. It is further submitted at bar that the present writ petition can also be disposed of in similar line. It can also be disposed of in terms of the aforesaid decision of this court. Stop. Next para. In view of the aforesaid endorsement made by the learned counsels for the parties, this court considering the petitioner similarly situated to the petitioners in WPC /1374/2024 allows this writ petition in terms of the decision rendered by this court in WPC 1374 of 2024 within brackets Sashadhar Shil versus State of Assam, by granting liberty to the petitioner to approach the concerned respondent number 3, respondent number 4, i.e. the Deputy Commissioner,
Deputy
Bongaigaon, seeking mutation in his name on the basis of his documents, and the said authority shall deal with such applications in terms of the observation which are made in order dated 9/2/2022 passed in WPC 4594 of 2022 and order dated 3/5/2024 passed in WPC 1374 of 2024. Stop. That's all. With the aforesaid observation direction, this writ petition stand disposed of. That is already set aside.
Set aside,
So I don't think
not necessary.
Not necessary.
Highly obliged.
39. Disposed of.
Yes. Lordship, in this case, the petitioner approached the insurance company for surrender his policy, Lordship, for his medical treatment, Lordship. But that was rejected. So the fact of the case is just, Lordship, the petitioner purchased a policy, Lordship.
Who is appearing for the respondents?
Appearing for respondent number 2. So we need to file our reply.
Mr. Your name?
Yes, Dash.
Mr. So-and-so, learned counsel for respondent number 2 seeks 2 weeks time to file a return in the matter. Stop.
That may be given, Lordship.
2 weeks. This is a 24 matter. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
May I please, Your Lord? This matter I will file affidavit in law point, my lord. He is seeking a certiorari against a judicial order of a statutory appeal.
59. Mr. D. Gogoi, learned counsel for the for respondent number?
My lords, I am the...
For respondent number so-and-so, 6. How much time?
2 weeks, my lord.
2 weeks time to file affidavit in opposition in the matter. Stop. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
All the respondents.
For the state respondent? Yes, for the state respondent.
Lordship, earlier interim may be continued.
Interim, if any, shall continue till the next date of listing.
Obliged, Your Lord.
Yes, Mr. Das. Case diary?
40 case diary is not received, Lord.
Not received. Await case diary. List this matter on
31st of May.
My lord, 75 days already.
Can you have it by 22nd?
22nd.
74 days, my lord.
I'm trying.
Try 22nd or 23rd.
23rd is holiday, I think.
24th?
Let it be 27. But we have message will go tomorrow only.
No, you see, the other difficulty is that this code shall not be available here from 27th.
My lord.
So you have it on before that because already 75 days.
22nd I will try.
22nd.
Yes.
All right.
41. This is my lord second bail application, my lord.
Yes. Case diary is there?
Case diary is there.
Yes.
The allegation is that I have stolen some goods, my lord.
You have stolen some?
My lord. The lordship will find the FIR, my lord.
FIR is at page?
My lord.
13.
Yes, my lord. May I read, my lord?
Yes, please.
Messrs. APG Logistics Limited, the complainant hearing is a company registered under the Companies Act 1956. The complainant is engaged in the business of logistics, shipment, having offices and work all over the India. Various companies. The company has loaded the consignment from other goods here to Betkusi. The logistics go down around 11 a.m. on February 27, 24.
You are the driver?
I am the driver. My lord. Somebody has, my lord,
Where is the earlier rejection order?
Rejection order, your lordship will find Annexure B at page 16, my lord.
Earlier it was AB.
Now it's what it is.
It's AB only.
AB, my lord. May I read, my lord?
What has changed?
Perhaps, my lord, recovery has been made, my lord.
You cannot you see, second bail applications are not review or not re-hearings, right?
That is
there
true,
must
my
be
lord.
some materials for you to approach this court. And this is not a case of a regular bail, it's a case of anticipatory bail.
My lord, then, my lord. Paragraph 4, my lord.
Yes.
May I read, my lord?
Please, please.
Earlier, a bail application being so and so was filed by the petitioner before this honorable court, and the same was rejected on 28/3/2024. Now no bail is pending. The ground of second bail application is that 1.5 years old child of the petitioner is seriously suffering due to illness, whereas his father, that is the petitioner, is not in a position to look after him due to apprehension of arrest.
Sorry.
If your lordship may
Sorry.
provide some section, then I will cooperate with the investigation, my lord.
Heard Mr. T.
K. Bhuya.
T.K. Bhuya, learned counsel for the petitioner, also heard Mr. Didas, learned APP, appearing for the state respondent. Stop. This is a second application under section 438 of CRPC for granting pre-arrest bail to the accused petitioner, namely Sharuf Khan, who is apprehending arrest in connection with Ajara PS case number 42 of 2024, registered under section 407-420 of the IPC. Stop. The case of the petitioner is that accused petitioner has the case of the prosecution, right, sir? Case of prosecution is that the accused petitioner has misappropriated 300 packages which were being transported by him as a driver of the truck to deliver the same to the requisite location. Stop. Mr. Bhuya, learned counsel for the petitioner, submits that the petitioner has 1.5-year-old child suffering due to illness, and hence the second application of anticipatory bail ought to be entertained. Stop. Yes, Mr. Das, has the truck been recovered?
No.
Mr. D. Das, learned APP, on the other hand, strongly opposes the prayer for anticipatory bail. He submits that out of the 300 boxes alleged to have been taken away by the petitioner while driving the truck in which the said boxes were being transported, only 50 boxes have been recovered.
That was earlier, my lord.
Yes, after that nothing has happened, you've heard. He further submits that the balance boxes are yet to be recovered. Stop. Pertinent to state that this court, by order dated 28/3/2024, had earlier, after evaluating the entire materials on record, rejected the prayer for anticipatory bail. Stop. The petitioner has failed to show any change of circumstances warranting entertain of the second bail application. Accordingly, the second bail anticipatory bail application also stands rejected. Disposed of.
42.
The case that is there, you know.
42.
Non-appears.
Okay. None appears for the petitioner when the matter is called. Retain the case diary list on Tuesday.